Speaker mode. Monday.
Monday. My lords, item 39, my lords, 39. For Mr.
Nine.
Raviraj. For respondent, my lords.
Appearing for-
Mr. Raviraj, my lords, has some inconvenience today. 2 weeks, my lords.
4 weeks.
2 weeks, my lords, after 1 week also.
2 weeks. The request of
Your Lordship, serial number 37, Your Lordships.
37.
Yes, Your Lordship.
Ah,
Your Lordship, in this matter, the outstation council will appeal, Your Lordships. Can we wait on 17th February, Your Lordships?
on 17th he is coming.
Yes, Your Lordships.
Friday will not. Monday. All right. Call on 17th at the request.
Right.
Millards, serial number 20,
Huh?
serial number 26, Millards.
26.
Millards, the impugned judgment relies on the decision of decision of the Tripura High Court, which is currently pending before the Supreme Court. The Honorable Supreme Court has listed the matter for final hearing in the second week of February. This matter may
On
kindly be
the fourth
taken
week.
post. Please, Millards.
There is a batch itself. Question is whether when they give a set-top box to a customer, whether is a team sale covered in the definition covered by the Constitution as well as under the statute. There is a batch pending before this honorable court, my lord. Matters are pending on the 11th of February
11th of February.
before our court.
We'll call this matter along with them and later we can decide as to what should be done. But Tripura, whether Tripura legislation and this legislation are pari materia.
There is nothing to do with Tripura, my lord. The matter is covered by the Constitution of India.
Okay.
The definition of sale in the Constitution of India is what we are relying on.
Okay.
I don't want to rely on Tripura at all.
Okay.
In fact, Supreme Court and BSNL says so.
But sometimes we travel to other states also.
Please, Millards.
As your lordships have held, the freedom of movement cannot be impeded in this manner.
That's what. Yeah, call this matter along with which is that? STRP number ಕೊಡ್ತೀರಾ?
I can quote it.
Along with STRP number so and so.
There is a batch.
Okay.
You do Tata Play though, then Dish Network, Den Network. There is a batch. I will give it to the court.
Yes, yes.
Please.
Serial number
Great.
36, my lord.
Ha,
36.
36. ಅಣ್ಣಮದ ಏನದು?
I had a well touched appeal, my lord.
Ha,
Requires some 3 weeks time to.
you want time? Why 3 weeks? 2 weeks will give?
Please, my lord. After 2 weeks, my lord.
Any special reason for 3 weeks? All right, call this matter after 3 weeks at the request of
Serial number 30, it's admission matter.
30.
30.
Huh.
File misplaced. Next week, I just.
Call next week at the request of
Serial number 34, my lord.
34. Huh.
Supreme Court remand matter, transfer pricing.
Remand matter, ongoing matter. No, the admission ಬಂದಿದೆ no?
Final hearing.
Final hearing ಬಂದಿದೆ. Call up to 4 weeks. At the request of court. Yes. Rounds.
Both respond.
We are following the petitions. Petition. We are broadly agreeing with your submission. We held that the pre-deposit is debt specific, not appeal specific or cost specific. So if there are multiple appeals and in one appeal amount is deposited, that will inure to the benefit of other appeals. But that being said, one question arises. Suppose one appeal is filed and amount is deposited. Then 2 more appeals are subsequently filed. The first appeal is withdrawn. What should happen to your appeals?
At that stage, perhaps, my lords, they should be called upon to
Deposit.
deposit.
But that we have not treated because that is not the fact matrix of the case. But we have just referred to Aaron Barak's purposive interpretation in law,
Please.
where he refers to explicit meaning of a text, implicit meaning of a text. We brought your case into implicit meaning of the text, which your senior Poya very often refers to that also.
Please.
So that way we have structured the judgment. And we have texted the operative portion of the order this way. Just see whether it is all right. In the above circumstances, this petition succeeds, a writ of certiorari issues quashing the impugned order. The subject applications are remitted back to the portals of the Debt Recovery Appellate Tribunal, Chennai, for consideration afresh in the light of observations herein above made. We have made the observation, one payment is sufficient.
Please.
That way. Then we have also said that because you took up the contention, the amount paid is not given deduction to.
Please.
That also should be examined. We have observed that.
Please.
All right?
Okay.
Okay. We have considered your contentions also, contentions of the senior advocate also. Our research assistant helped us a lot. Therefore, we have put appreciation for him in the judgment.
Please.
Yes,
Grateful.
Grateful, my lords.
yes. Two. Memo.
My lord, I beg to appeal for the.
Ah.
I believe the petitioners have filed a application under the Kar Samadhan scheme. It may be deferred by a month time.
So then memo noted.
Oh, it's mine, my lord.
Your
I
memo,
have filed.
yes.
The appellant was required to file the e-sucum certificate, which he has not done as per last order.
Yeah, you were
Yes, my lord. Now they are
Sukuma certificate.
My lord, they are availed some Kar Samadhan scheme and they have filed an application, I believe. They may be.
You want some more time?
They filed it by a month's time, that's all.
Call after 2 weeks for reporting compliance of the order dated 8/1, order dated
That's 10/6/24.
10/6/2024. Okay. ನಮ್ಮುಂದೆ ಬಂದಿತ್ತಾನೆ ಇದು
Much
10/6 ನಮ್ಮುಂದೆ ಬಂದಿತ್ತಾ? Okay. Yes, Sanmati.
My lords, 3 and 4, my lords, needful done in the morning, my lords. Needful done.
Not about. Needfully stated to have been done, registry to verify.
But when 5, may I be permitted to take notice?
Exalted.
Srimati so and so. Accepts notice for respondent. RCC. Or the copy pudi?
I'll also have a copy.
Yes. ಈಗ dispatch ಮಾಡ್ಯಾರ. Yes, very easy.
Yes, sir. All
Yes,
right,
sir.
no? Sir, I have sir, given the copies to the opposite party through email, sir.
You have sent
Yes,
the
sir.
copy now? You have
Yes, sir.
received, Mr. You have sent by email, na?
I have received, but not entire set, but fine, I will argue me.
Your entire set
Not
is not
entire
given
set.
to you.
Not entire set.
Anyway, you have received that, you have
Yes,
the
Milord.
sets, na,
Yes,
now?
yes, Milord.
All right. Yes, sir. Argue.
Yes, sir.
Yes.
Yes, sir. In this case,
Ah.
the respondent has not obtained the probate of the will.
Has not obtained?
Yes, sir. Even though a will has exhibited 2015, he came to know about the will in the year 2015. So far, he has not obtained the probate.
What is the order challenge here? Just show me, brother.
Order challenge in the
ಅದು plaintiff ಇನ್ನೂ notice await ಇದೆಯಲ್ಲ?
ಅಲ್ಲ ಅವರಿಗೆ ಬೇಕಲ್ಲ actually it's
Wait,
against
eh?
me.
Ah.
They filed an application against me. I am the second defendant, my lord. What has happened, my lord? It is like the suit for partition filed. in the suit, I took up contention. I'm the second defendant. I took up a contention that my father, admittedly, it was the absolute item number 1 of the suit share property was the absolute property of my grandfather. And after his death, there was a partition. In that, their property has been allotted to the share of my father. And my father had executed a will in my favor. Based on the will, I am absolute owner of item number 1 of the suit share properties.
Yes.
For that, my learner, the defendant number 1 has filed an application. One under order 12 rule 6, saying that there is a admission in the written statement, suit has to be decreed. Second application, under section 209 of IPC, read with section 340 of CRPC, in that he made the counsel who is appearing for defendant number 2 as party, seeking action against the defendant number 2 and against the counsel for defendant number 2 for making false statement. That application has been rejected by the trial court. That orders have been challenged in the writ petition. This honorable court, learned single judge, has dismissed the writ petition with the cost of 10,000 because he made false allegations against the counsel and also made him as a party in the application. Again, that this writ appeal has been filed.
Yes. But how, brother, how, Mr. Rao, how intra-court appeal is maintainable in view of a full bench judge, 5-judge bench decision?
Because, sir, the IA number 15 filed by me has not been adjudicated even after 3 years of filing the adjudication. That file, sir. I came to this writ court for speedy justice, sir. They are not passing the order. Even after 3 years of filing the IA, I had, many times I have argued before 3 judges
Which,
in 3 years.
All right. Which IS they are? Tell me. Tell us.
They
Which are those IS?
Number 15, IA number 15, under order 12 rule 6, sir.
No orders are passed on that application, brother.
Yes, sir.
That has been, those applications have been rejected. It was filed
Not
in
rejected.
22, my lord. Those applications have been filed in 2022. In 22 itself, it was rejected. 23.
Where is that order?
That order has not been furnished to me, my lord. Again, that he filed a writ petition.
Sir,
Where is that?
sir,
That is, may I submit
Buddy.
all copy codes, writ petition.
Your applications are still pending.
still pending, sir.
Which are the applications pending?
IA number 15 and IA number 32, sir.
No, they are dismissed and challenge to that order also is dismissed.
No,
You have not seen
dismissed.
that WP number.
Writ court dismissed on against to the statutes and the settled principles of law, sir.
Correct.
Yes, sir, because
So you
the
can't
orders,
say they are pending now.
no,
Rightly,
wrongly,
wrongly.
sir, the order passed by the writ court is per incurium.
That is another thing. Per incurium is a different concept. You
Yes, sir.
can't
Because
cite in.
that serious
understand.
injustice caused to me.
Please understand. Res judicata is different. Per incurium is different. A judgment may be per incurium, but it binds the parties. You can't cite it as
Yes,
a
sir.
piece of law. That's all per incurium means. Nothing beyond that.
Sir, nowhere it has been dismissed. The IA number 15.
Yes.
What the learned judge in writ petition told that respondent to a set up a will, it is to be inquired, trial.
Okay.
Because it is this one, right of a daughter is no more res integra.
Okay.
It is well settled in the orders of the Supreme Court and also High Courts, many High Courts.
Yes.
But I came to writ petition for speedy justice only.
Okay.
Then
Adna, suit and bega
it
mugisi
got dismissed. Yes, sir.
suit and bega mugisi anta order ಮಾಡನ ಬೇರೆ
Yes,
ಏನಿಲ್ಲ
sir. That is
ಸುಮ್ಮನೆ
what-
ನೀವು ಯಾವ್ದಾದ್ರು ವರ್ಡ್ ಉಪಯೋಗಿಸ್ತಾ ಇದ್ದೀರಿ ಸೂಟ್ ಅಂಡ್ ಬೇಗ ಮುಗಿಸಿ ಅಂತ ಹೇಳೋಣ
ಯಾಕಂದ್ರೆ
ಹ್ಮ್.
IA ನಂಬರ್ 15 ಗೆ ಅವ್ರು ಹಾಕ್ತಾರೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಫೋರ್ತ್
Anyway, that both IAs are rejected. You challenged it in a writ petition. Writ petition is also rejected. Now you are saying it is per incurium. That idea is ridiculous to say the least. Now, at the most, what we can do is we can ask the learned just to try the suit expeditiously. That
Yes,
will
sir.
do justice to you. All right?
Yes, yes, sir.
Perfect. The challenge in writ jurisdiction is to the order of a learned single judge dated 29/8/2023, whereby the challenge to the order of the court below has been having been examined is upheld. First, learned counsel for the petitioner submits this could not have been done when there is abundant evidentiary material on record. First, 10,000 rupees cost ಹಾಕ್ಯಾರ ಅದನ್ನ ಡೈಲ್ಯೂಟ್ ಮಾಡೋಣ ಕಾಸ್ಟ್ ಏನ್ ಬೇಡ.
Yes, sir. ಯಾಕಂದ್ರೆ
Correct, but what he has done, he made allegations against the counsel for producing the will and written statement. This is the way they are doing.
ಹೇಳೋಣ ಇನ್ಮೇಲೆ ಆ ರೀತಿ ಮಾಡಬೇಡಿ. ಲಾಯರ್ ಮೇಲೆಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡಬಾರ್ದು.
ಸರ್
ಅಲ್ಲ, ಅದು ಏನು ಅಂದ್ರೆ
ನೋಡಿ, ನೀವು ಈ ಕಂಡೀಷನ್ ಒಪ್ಪಿದ್ರೆ ಕಾಸ್ಟ್ ಅನ್ನು ಡಿಲೀಟ್ ಮಾಡ್ತೇನೆ. ನೀವು ಅದಕ್ಕೆ ಒಪ್ಪದಂಗೆ ನೀವು ಲಾಯರ್ಸ್ ಮೇಲೆಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡಿ ನಾನು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು ಹೆಂಗೆ ಎಲ್ಲರೂ?
ಅಲ್ಲ ಸರ್, ತಪ್ಪು ಮಾಡಿದ್ರೆ ಹೇಗೆ ಮಾಡೋದು ಸರ್? Just because of that trial of
this intra-court appeal is not maintainable.
Can you dilute the cost, sir?
No, you are not agreeing to the very proposal. First you admit.
I am agreeing. I agree, sir, for the dilution of cost, sir.
Deletion of cost ಗೆ ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಬೇಕಿಲ್ಲ, ನಾವು ಮಾಡ್ತೀವಿ ಬೇಕು ಅಂದ್ರೆ. Provided you agree that hereafter you will not make allegation against lawyers.
Okay, sir.
He has agreed not to this. Anyway, this video will be available to all of you for comments, etc.
The difficulty is this, my lord, because the advocate has filed retirement saying that there is a will executed by the father in favor of son. So he said that.
ಈಗ ಲಾಯರ್ಸ್ ಮೇಲೆ ಜಡ್ಜ್ಗಳ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡುವಂತ ಒಂದು ಬಿರುಗಾಳಿ ಬೀಸಿದೆ. ಅದಕ್ಕೆ ನಾವು ಬಹಳ ತಲೆ ಕೆಡಿಸಬಾರ್ದು.
Please.
ಅವ್ರು ಹೇಳ್ತಾರೆ ನಮಗೆ ಬಂದಂಗೆ ನಾವು.
Even without hearing us, learned single judge has imposed court. That's why.
ಇದು ಇನ್ನು ಬಂದಿದೆ ಇದು. Dismissing already. Didn't recall borodu miss. We have followed Renuka and others, na? Varale Saab and myself. The petitioner has moved the application in IA number 1 of 2023, supported by an affidavit seeking recall of a coordinate benches order dated 12/10/2023, whereby his writ appeal number 1244 of 2023 was negatived on the ground that such an intra-court appeal is not maintainable. First, no grounds are shown as to why we should recall this order, law being declared by the 5-judge bench of this court. 7 judges, sir. Renuka is 7 judges. 7-judge bench decision of this court in Renuka versus Tammanna. Tammanna. First, next paragraph. The above being said, this court, on the assurance of learned counsel appearing for the petitioner that hereafter he shall not make any allegation against any members of the bar representing the parties, what you have written, comma, the cost of rupees 10,000 levied by the trial court is waived. All right. Next paragraph. Learned judge of the court below is requested to try and dispose of the suit as expeditiously as possible. First of all, contentions are kept. Please. All right. But I dismissed. Yes. Next.
I prayed for 10 days time to come.
You want 10 days time? Do you have objection?
My lord, this matter is pending for the last 24 years.
Ah.
More than 100 employees died already. And the single bench has already given direction to pay the VRS as per the orders of the court, division bench.
Next week, Madi. Huh? All right,
The date, my lord.
all right. Call this matter on the other one date. Kodi. 6th of February. All right. Finally, at the request of counsel for the appellant. Next. In the meanwhile, office objections to be attended. Okay.
So serial number 8 and 9, my lords. I'm filing a better affidavit, my lords, tomorrow. It's been signed today, my lords. I'll file it in first half today, my lords, or tomorrow, my lords.
Call next week at the request of for filing better affidavits. Okay. Sanmati.
3 days time.
Huh?
3 days time.
But 3 times already third time ಕೊಟ್ಟಾಗಿದೆ.
Your Lordship,
ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಟ್ಬಿಡಿ.
within.
ಮತ್ತೆ ಒಳ್ಳೆ ಪುಸ್ತಕ ನಮ್ಗೆ ಟೈಮ್ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಪುಸ್ತಕ ಕೊಡಬೇಕು. ಅದ ಪ್ರೈಸ್. ಬುಕ್ ಇಸ್ ದ ಬೆಸ್ಟ್ ಪ್ರೈಸ್ ಫಾರ್ ದಿ ಟೈಮ್ ಸ್ಪೆಂಟ್. ಯಾವ ಪುಸ್ತಕ ಕೊಡ್ತೀರಿ?
Your Lordship, Bharatiya Vidyavan by KG Raghavan.
ಭಾರತೀಯ
There's a book called, my lords, from Mr. KG Raghavan, called, my lords, from Ramayana Sri Ramakanda, my lords. It's a very
Ramakanda.
small, my lords, where he has sort of given an English translation, my lords.
that book.
Yes, my lords.
Ah.
The senior advocate.
1 week time granted for complying with the office objection, subject to the condition that the appellant shall present 2 books of ಯಾವ book ಅದು ಕೊಡಿ, so and so, authored by Mr. KG Raghavan, a senior advocate. ಒಂದು ಕೊಡ್ಬೇಕು.
Yes,
ಕೊಟ್ಟು ನೀವು ಓದಬೇಕನ್ನ.
ಇವತ್ತಿನ
ಕೊಟ್ಮೇಲೆ ಮುಗಿತದ, ನಾವು ಓದಂಗಿಲ್ಲ ಅನ್ನಂಗಿಲ್ಲ.
ಇಲ್ಲ ಇವತ್ತಿನ.
ಓಕೆ.
Seal number 10 to 13, my lord.
ಹಾ ಸೇಮಾ?
Same, my lord.
ಇವೆಲ್ಲವಕ್ಕೂ ಒಂದೊಂದು ಅಂತ ಬೇರೆ ಬುಕ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಇದು ಒಂದೇ ಬುಕ್ ಕೊಟ್ರೆ ಓದೋರೆ ಸ್ವಲ್ಪ
ಇನ್ನೊಂದು book
ಭಿನ್ನತೆ
ಕೊಡಿ.
ಬೇಕಲ್ಲ.
I will give one more book, my lord.
ಯಾವ್ದದು?
Your Lordship, ಸುಧಾಮೂರ್ತಿ ಅವ್ರದ್ದು ಒಂದು ಡಾಟರ್ಸ್ ವಿಶಸ್.
ಕೇಳು ಕಿಶೋರಿ.
Please, my lord.
ಕೇಳು ಕಿಶೋರಿ.
Kill.
ಅಲ್ಲ ನೋಡಿ, ಸುಧಾಮೂರ್ತಿ ಅವ್ರದ್ದು ಕೇಳು ಕಿಶೋರಿ ಅನ್ಕೊಂಡಂದಿದೆ ಅನ್ಕೊಳ್ಳಿ.
Please, my lord.
ಇನ್ನೊಂದಿದೆ ಮಹಾಶ್ವೇತೆ ಅಂತ ಒಂದಿದೆ,
Please, my lord.
ಅದನ್ನ ಇನ್ನೊಂದು ಕೇಸ್ನಲ್ಲಿ ಕೊಡಿ.
ಇನ್ನೊಂದು ಕೇಸ್.
ಮಹಾಶ್ವೇತೆ ಬೈ ಸುಧಾಮೂರ್ತಿ. Shwete, she was suffering from absolute leukoderma, so she looked very, very white. She called it as Mahashwete. Yeah. All right.
Your Lordship, 1 week, my lord. Same.
30. ಇದ್ರಾಗ ಏನ್ ಕೊಡ್ತೀರಿ? ಲಂಕೇಶ್ ಅವರ ಪಾಪದ ಹೂವುಗಳು ಕೊಡಿ.
Please.
ಚೆನ್ನಾಗಿದೆ, ಲ್ಯಾಂಗ್ವೇಜ್ ಇಸ್ ಗುಡ್. ಐಡಿಯಾ ಯು ಮೇ ನಾಟ್ ಅಗ್ರಿ. ನೋಡಮ್ಮ,
ಎಲ್ಲಾದ್ರಲ್ಲೂ 2
ಹೂವುಗಳು
weeks
ಬೈ.
ಮಾಡ್ಬಿಡಿ ಸ್ವಾಮಿ.
ಆಲ್ ರೈಟ್, 2 weeks ಮಾಡಿಬಿಡಿ ಎಲ್ಲ ಕಡೆ. ಆಲ್ ರೈಟ್. ನೆಕ್ಸ್ಟ್.
Please, my lord.
Mr. Reddy,
My lords, may I request 2 weeks time to comply with office objection?
ಏನ್ ಆಫೀಸ್ ಎಷ್ಟು ಸರಿ ಕೊಟ್ಟಿತ್ತೀಗ?
My lords, the office objection is non-filing of translated copies of Kannada documents.
ಟ್ರಾನ್ಸ್ಲೇಷನ್
My
not
lords,
been yes.
they've already been filed. However, it was filed with the memo, not with the petition. I'll. It, my.
ಈಗೇನ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಬೇಕಾಗ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಫಾರ್ ದ ಟೈಮ್ ಬೀಯಿಂಗ್ ಈಸ್ ಓವರ್ ರೂಲ್ಡ್. ಏನಿದು ಮ್ಯಾಟರ್?
My lords, I'm being.
ಇದೆಯಾ? ಅಪೋನೆಂಟ್ ಯಾರು? ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿ.
I'm being led by a senior advocate, my lord. He's little unwell today. May have
Unwell?
any time next week.
All right. Call after 2 weeks, entry more to continue for 2 weeks.
Much of.
Okay.
I appear for the petitioner bank, my lord.
Yes, Guru.
Yesterday, I have received the copy of the counter by post, my lords. This petition, may I continue, your lords?
Hello, you are comfortable today to argue?
Yes, yes.
Because yesterday you received it, na?
It's okay.
That is,
Please.
come on. Yes, ready?
Yes, sir.
Come on, argue.
May I proceed, your lordship?
Yes, sir.
My lords, petition is filed against the impugned order at annexure E, which is before your lordships at page 26, in page 26, my lords.
1 second. 26. What is this order?
My lords, by the terms of this order, dated 30/01/2024, the Honorable State Commission has transferred 3 cases, pending cases, from one court to another. That is at the behest of the respondent, complainant, to the choice of his court members. He seeks for a transfer of the 3 cases to a particular court.
How many courts are there?
Totally 1 plus 4, my lords, 5.
5.
My lords, matter is 1. I'm sorry, I interrupted you.
That's all.
Please, I'm sorry. Matter is one ground. 2, the manner in which this application came to be allowed. There is no application, my lords. There is no application filed.
For transfer, no application.
No application is filed. I have not heard in the matter. And there are contrary notings in the order sheet. May I take your lordship's kind attention to the same, please?
ನಿಮ್ಗೇನು ಅದೇ ಕೋರ್ಟ್ನಲ್ಲೇ ಇರಬೇಕು ಅಂತಿದೆ
ಇಲ್ಲ, my lords. No, because he has a habit.
ಈ ಕೋರ್ಟಿಗೆ ಏನ್ ಮಾಡಿದಾರಲ್ಲ ಈಗ ಇದ್ರ ಬದಲಿ ಇನ್ನೊಂದು ಕೋರ್ಟಿಗೆ ಕಳಿಸಿ ನೀವು ಇಬ್ರು ಖುಷಿ ಇರ್ತೀರಾ?
My lords, at the onset, I wish to place on record, I have no objections absolutely to wherever it is posted. But the petitioner is in the habit, the complainant, respondent, he is in the habit of seeking for transfer arbitrarily at various stages, according to his convenience. That practice should be deprecated. That is why this petition is filed.
They have transferred it to which court?
3rd additional from 1st additional district forum.
We will transfer it to 2nd additional court. There you can conduct the matter, all contingency. Why 3rd additional?
No, I have
No,
not
he
said.
say, you made a, where
No, sir,
is
no.
your application? Where is your application for transfer?
I have already filed with this thing, sir. They have already, it is there in this.
Why unnecessarily it should be transferred? On what ground? Because you asked it should be
No,
transferred.
no, no, definitely not, sir. Definitely not, sir. Sorry, sir.
Right.
Sir, the first application was filed by the opposite party for transfer of some complaints which I had filed.
ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿ ಗೊತ್ತಾಗತ್ತೆ.
No, sir. My lord, his mother tongue is not Kannada, Your Lordship.
Okay.
Sir, first application was filed by the opposite party when I had filed some complaints in DC number 1, court number 1. Without my knowledge, without any calling me for any, the transfers were affected from the 1st, 2nd to the 1st. Without any notice to me, without any reference to me. The cases were going on in the first thing. Subsequently, I had filed some more cases which were going on. The very reason for this is,
Where in which court instead of all this, you want justice?
sir,
You want justice. You went to court because consumer forum because you wanted some justice.
yes, sir.
Is it not?
Yes, sir.
So we will send, how many cases are there as between the parties?
My lords, at Annexure A, page 17, my lords, he is a serial litigant.
Yes,
Yes, I am. I agree, 100% I agree. Because there is deficiency of service and I have been awarded.
No, we have not disputed it.
I am awarded. I am not disputing. Yes, I have been awarded. Sir, one more thing, sir. Now, there are three cases here which have been transferred. I'll just tell you, sir. Case number 220. They have already filed a writ petition and they've got the orders.
Total cases ಎಷ್ಟಿದೆ?
9, my lords.
Pending cases 9 ಇದಾವ?
Yes. At page 79, some of them have been disposed of, my lords.
Pending ಇರೋ ಎಷ್ಟಿದೆ?
So these are the 3 cases pending. One is pending with the National Commission. They have gone to the National Commission.
ಬಿಡಿ ಅವ್ರು ಹೋಗಿರ್ಲಿ. That's not the point. Which are the cases pending before the
For
forum?
5, my lords. The list is at in page 17, your lordship. Annexure A, 17, 18, please, my lords.
17, 18.
Yes, my lords.
ಅದು A, B, C ಇದೆಯಲ್ಲ ಅದು?
Serial number 2, my lords. Serial number 2 is pending.
ಅಲೋ ಆಗಿದೆ ಅದು.
Yes, no, my lords. 2 and 7.
2 is allowed, na? Appeal number 106 of 20.
Sorry, my lords. That is allowed. Yes, sorry, your lordship. 2 is allowed.
Pending ಯಾವ್ದು?
Sir, there are only 3 cases pending which have been transferred. That is all. Out of that, one is pending with the National Commission.
Out of 3,
One is with the National Commission.
That's all right. We need to talk about
There
that.
are two.
Two or which
Two
are
are
there?
here. Yes.
Tell that detail.
At the same, out of two,
Give number detail. Give the full particulars of those
yes,
cases.
two was 199 of,
You know, complaint or appeal or, you know,
my complaint is of 199, number 199 of 2023. Yes,
complaint.
complaint, CC. And the other one is 220,
CC 199 of
23.
2023. This is pending in which court? Quota number 3.
No, it is
Now
not
before
23.
three, yes.
No, it is 3, yes.
Another
Second one,
case is
220 of 23.
CC.
CC.
220 of
23.
only 2 are pending now.
Only 2 are pending. And sir, out of these 3 cases which have been transferred, they have already filed a writ petition in the 220. And it has been allowed. It has been allowed.
Yes.
Adeli there.
It is allowed.
It's been remanded back.
Matter is
Yes,
remanded.
remanded.
Ade yavdu CC 220.
Same, that is 220 minutes.
All right. Only 2 cases are pending.
And EP is also pending, 54, pending the orders of the National Commission.
EP 54. Huh?
54 bar 23, your worship.
54. National Commission will stay there, no?
Revision, yes.
Stay there.
Stay for the proceedings is granted.
ಹಂಗಾಗಿ CC 199, CC 220 ಇದಾವಲ್ಲ,
Yes,
ಅವುಗಳನ್ನ
yes,
ಕೋಟಲ್ ನಂಬರ್ 2 ಹಾಕೋಣಂತೆ
yes, sir.
ಅರ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಆರ್ಡರ್ ಮಾಡಿಬೋದು.
Yes, sir.
ಇಬ್ರು ನೀವು ಅಪಿಯರ್ ಆಗಿ ಅಲ್ಲಿ ಹೋಗಿ.
Sir, if I can take your little time, sir. You say that stay has been granted. Can you kindly see, sir? Page 14, there is no stay order, but they have filed a false memo with a false date. That is why this transfer have been taking place. Sir, if you can.
1 second, you have said should not be processed.
Sorry, sir.
Sit down. Sit down, sit down.
No, it's okay, sir. Okay.
No, you'll have to sit down.
No,
First,
please, please.
then we will not hear this matter. Interim order to continue. Call after 8 weeks. Next.
Sir, my apologies, sir, please.
What is this? You are, see,
sir,
you
sir,
do not,
sir.
we are saying, we are asking you. Therefore, you should engage lawyers. This is the problem.
Sir,
Spend lot of our time. That so much time is not with us. We have to ration the time.
no, sir,
Even we
that-
are not here to train you in law and get argument on legal arguments. That will be
Sir,
impossible for us.
Sir, as for the, if.
We are telling, you can't have the court of your choice. There are multiple courts, number 1. Number 2, we are sending you to another court beside. You go and get the matter disposed of. Why you are insisting upon the same court? Suppose if somebody says,
Sir,
no, you only decide this case,
Sir,
what will you say?
Sir, I have never insisted on any.
Now, therefore,
I have never insisted on.
Understood
any
the
particular-
point.
They
Now-
themselves have transferred to some court. No, sir. What
we
we are saying-
transfer the matters to another court now.
Sir, that is okay, sir. But before that, can I have something? Whatever only I have just, nothing. I want to go 2 minutes.
Tell.
They have said there is no stay order in the National Commission.
You tell it to the court.
I have told them, sir. That is why this. sir,
Therefore,
that is-
we'll ask them.
Sir, that is why
All right.
that is why the transfer took place.
1 second.
That
Now,
is why the transfer took place.
all right. Now we will say, let these matters be decided neither in his court nor in the court of his choice nor the court of your choice.
Sir,
It will be decided by the court of our choice.
Sir, it was never my choice.
Anyway,
It was
now
never my-
very well. Then you should not have objection to our proposal at all.
No,
if
I'm
that
not.
is the case.
I'm not. Only thing I want to clarify,
Ah.
it has never been my.
Understood,
But
understood.
they have given a false statement.
All right.
They have given a false statement, sir.
All right.
I'm sorry.
All
I have never said for anything. You give me anywhere. Sir,
You want to waste time of the court?
I'm sorry, sir.
Please.
Sir, I'm ready. You can find what are final orders.
Perfect. Having heard both the sides, we are of the considered opinion that all the 3 cases, namely CC 199 of 2023, CC 220 of 2023, and EP 54 of 23 shall be heard and decided by additional court hall number 2. Neither you that court nor this court, court hall number 2. As expeditiously as possible.
Sir, can I say one more?
All
thing?
contentions of the parties are kept open. Yes,
Because
next.
this one particular case of 220, this thing was transferred from 2 to 1.
Therefore, we are sending it to 2 now.
Okay, sir.
Okay. Next, all.
Thank you, sir.
All contents of the parties.
My
are kept.
apologies, sir. I'm
No, no,
sorry.
it's all right. It's all right. It's all right. Okay. Additional quote hall number? Guru, additional quote hall number?
The new court, no?
Huh.
Two, to be transferred to second edition.
Second additional, okay. All right, perfect.
It was from second itself, it was transferred to first, from first to third, now again back to.
Now back to the two.
That is only one case. The other two cases are different.
All cases in one court.
My
It becomes easy for you.
Sir,
Parties are directed to appear before the said court without any further notice. On which date you will appear before the court?
I'm ready tomorrow. Tomorrow I'm ready.
He is in urgency, but we cannot go that fast.
A week's time kindly, my lord.
Huh?
The date may be fixed, a week's time kindly.
On, no, on the other date. 10th of February. Okay. Next.
On behalf of the advocate for the petition.
For the second responding.
For the
First committee for permission to litigants ಇದೆಯಲ್ಲ ಯಾರು ಇರ್ತಾರೆ ಅದರಲ್ಲಿ? Registrar judiciary ಬರಕ್ಕೆ ಆಮೇಲೆ. Okay. Yes. Yes, Mr. Joshi. Yes, good.
It is an interesting petition, my lord. A different question of law arises here. I am a site purchaser. Respondent number 1 is a developer. Respondent number 2 is the landowner. The landowner and the developer have a joint development agreement for development of a project. Project is being developed. I am one of the purchasers. I have been allotted a site. I am going to purchase. Several other persons like us have already purchased the properties. These two are having a fight amongst themselves. Between them, there is an arbitration clause in the joint development agreement. Landowner now wants to terminate the JDA and they are fighting among themselves. Because it is an arbitration proceeding, I don't have an audience there. I cannot participate like in a suit. Under Order 1 Rule 10, if there is a list going on which affects me, I am entitled to participate. In an arbitration, I am unable to participate. There are some interim orders being passed. In the light of Section 42A of the Arbitration and Conciliation Act, these arbitration proceedings are confidential. So I don't even have access to what is going on. Eventually,
Last sentence? Repeat last sentence.
Section 42A of the Arbitration and Conciliation Act.
Arbitration.
Statutorily, these proceedings are confidential. So as a third party, I do not have a right to even know what's going on. So adjudication of certain rights emanating from that contract is being done in that private tribunal chosen by them, which will affect me. I don't have access to justice. So I am standing before this honorable court that in a list of this nature, they should not be allowed to arbitrate. They should come before a court of law. Because I can go file a suit, but if this arbitration continues and some adjudication happens, my rights get prejudiced. 42.
Are you, suppose if they agree that you can also be made a party, are you agreeable to that?
Well, I need access to a forum which will adjudicate.
That's all.
That's all.
We'll ask.
The law
what
of
do you say?
arbitration.
Because whatever arrangement you are litigating upon, that may prejudice rights of the site buyers.
True, my lord, but the question is, can you invoke the Article 220?
No, it's not. No. Yes. It is possible. Now, again, it arbitration proceedings, because they partake the character of judicial proceedings.
Sir, as far as I am concerned, second
Now, we are asking you, are you agreeable to have him?
May I say something else, my lord?
come on the
Once-
arbitration.
You have no objection.
May I say something? I am for the developer, my lord. He's for the landowner. The nature of this dispute involves much more than the arbitration can contain. And I'll say why. There are 3 properties in one project. Property number 1, there is an arbitration going on. Property number 2, there is a suit going on. Property number 3, my claim against him is that he has not acquired that property from the neighboring parties. He says that about 20 properties he has acquired. With them, there is no arbitration clause. It has to be a suit. So therefore, on the whole of it, on a 360-degree view, arbitration is only a minuscule portion, but it is affecting everybody else. Therefore, on a question of law, irrespective of which side the facts, on the facts, I now belong to the respondent. But on a question of law, my lord, following Vidya Drolia, that says the court is the de facto fallback mechanism. That's the latest proposition. Following that, and Sukanya Holding says that if there is an arbitration partly governing it and a suit partly governing it, it has to go the suit way. That is settled by the Supreme Court. Following that, my lord, notwithstanding the fact that I'm a respondent, following this on the question of law, lordship may, because it's a very important question, it's come up for the first time possibly in any court in India, as to whether under 226, 227, lordship can intervene, say that because larger interests have now formed a basket of contract, which is outside of the original principal contract, several third-party interests, including banks. And today, being a developer, I am faced with several claims. He is just one. Another party has invoked arbitration in a separate agreement. That's a separate agreement. A third-party vendor has joined hands in his arbitration, whereas I have a Delhi arbitration with him. That can't be contained in this arbitration. So by nature, my lord, a matter of this has to be tested. This has never been tested in a court of law. When a small portion of a dispute, notwithstanding that small portion is the principal agreement, is amenable to arbitration, but thereafter it has resulted in multiple contracts, multiple transactions, all of which cannot be contained in one proceedings, following Sukanya Holdings, Sukanya Holdings and Vidya Drolia, should it not go the civil suit way? That's a large question that lordship is today confronted with. Lordship may return a finding on this. He can join arbitration, but there are several other interests. Firstly, he has not participated in the appointment process, and there are several parties who have not participated in the arbitrator appointment process. That's a valuable statutory right everybody is entitled to. So another party may come and say, I have not participated in the arbitrator appointment process. Why should I subject myself to arbitration? Therefore, there are so many such issues involved. Lordship may hear this matter, lordship. A finding on the law may be returned.
My lord, this will be the other side of the coin in terms of chloro controls. Chloro controls, my lord, is familiar, where there were multiple contracts between 2 or 3 parties, some containing an arbitration clause before one forum, some containing an arbitration clause before another forum. The Supreme Court laid down the law saying that since all of you are connected, arising out of one contract, all of you go for arbitration. Here, we will have to look at the other side, that where there are multiple projects, multiple landowners, some have arbitration, some don't have arbitration. One of the landowners, in fact, has already instituted a suit. That suit is going on in Devanhalli. These two are deciding some list amongst themselves privately. I don't have any justice. In fact, my lord, interestingly, if I may just show this, my lord, in the UK, this kind of situation has been addressed by legislation. Sir, I'm led by it.
We have no such legislation. No, we lead, each other will lead.
No. I was pointing out.
My lord, as far as now I am concerned, your lordship,
Just
as
point out.
he is appearing for the first respondent. As for second respondent, let him join the arbitration class.
Lord, I will point out,
And
Lord, I
I-
appear for the petitioner. My lord, this raises an important question of law.
Just Mr. Joshi said that.
And my lord, the question, my lord, really is how an arbitration which has a direct impact upon A, but A is not a party to the arbitration agreement entered into between B and C, and there is a contract between A and B. Now, my lord, what has happened? Kindly see, my lord. There is a contract here entered into between the petitioner, admitted facts, between petitioner and the respondents in the arbitration.
But there is no law appears to be, this is called in jurisprudence, we call it as non-liquid. Means where there is no legal norm at all, either by the legislature or by the decision.
The law is now settled.
That
The law is now settled. Having regard to the law laid down by the Honorable Supreme Court in Cox and Kings, the law is now settled that a third party cannot be a party to an arbitration.
Correct.
Now, I am a third party to the agreement between the two respondents here, who are the claimant and the respondent in the arbitration proceeding. Therefore, my lord, if it affects my right, which it does, because so in fact, in an interim order that has been passed by the arbitrator, he says that my agreement is vitiated by fraud. How can that finding be recorded? I ask myself, in an arbitration to which I am not a party.
You ignore that.
My lord, no, I can't.
But
because
it's an inter-party.
No, my lord, what happened my lord, is this. Now, the relief in the arbitration is that the agreement entered into, that the development agreement entered into between the two respondents is null and void. Suppose the decree is granted. What happens to my right? I am a purchaser of a flat.
You can always go for a suit.
No, when the agreement itself is not there.
Who said that?
But that arbitrator,
You are not a party to that.
I am not a party.
If it were to be a judgment in
But then-
your argument, we would appreciate it.
That is why
You go to suit.
No, but that is why, my lord, Supreme Court says that where a finding of declaration is what is called as omni agris, then the arbitration cannot go on. It is not arbitrable. Civil suit is the remedy.
No, if it is arbitrable or not, what is your locus standi to say about that?
Well, I am because
You enforce, go to lower forum, go to civil court.
What am I going to enforce? Am I going, well, kindly see the situation of that kind now. Here is an arbitral award as between the two respondents, which says that the agreement entered into between them is null and void.
Yeah.
Now, I am a purchaser under the very same development agreement which has been entered into between them.
With whom?
Between the two respondents.
To whom you are a party to which agreement?
I am a party to the agreement under which I have agreed to purchase a flat
With
which is being developed by one of the respondents in the writ petition.
You file suit against him.
But if the arbitration, if the development
Arbitration says,
yes,
how are you aggrieved by that?
But I am aggrieved because
Yes.
it will have a direct impact on my agreement. Then they will say that the agreement under which you derive a right, namely the development agreement, has itself been declared to be null and void in an arbitration,
Which will not bind you.
which is not binding me. Then what am I going to do in a situation of that kind?
No, you have to work out your remedy under section 9.
But I understand, Lord. I have to file a separate suit.
Yes.
But here is it now, my Lord, in a situation of that kind, the court will be faced with two situations. One, a award as between the claimant and the respondent in the arbitration, declaring that the DA is null and void. So that goes. Here is a suit that is filed. But that will go if there's a award.
It goes only in 4 jurisdictions, sir, where it is admiralty, insolvency, matrimonial, and one more is probate.
Yes.
If in those 4 jurisdictions, judgments are rem.
Yes.
That award is absolutely in personam.
That whole difficulty.
You proceed against the concerned person with whom you have entered into an agreement.
But there, my lord, there's a slight deviation in the general principle that your lordships have put to me, my lord, on which I can have no quarrel. I understand, my lord, section 41, 42 of the evidence. I understand. I fully bow down to what your lordship saying. But in Booz Allen, the Supreme Court said that where an award is going to affect the rights of a mortgagee who is not a party to the arbitration, such a matter is not arbitrable. Because those are all third parties are going to be affected. If by an award, an interest of a third party is likely to be affected, then it is what both in Booz Allen, as followed, my lord, in Cox and Kings, Supreme Court said these are all omne regis against the whole world. The independent of the proposition that your lordships have been put to me. Manamana, kindly see the judgment of the Honorable Supreme Court in Booz Allen. Yes, thank you. 2011, volume 5, SCC 538.
Well, paragraph. That means these 4 conventional jurisdictions. One more is added by the Supreme Court.
Yes, respectfully.
Kindly read.
My lord, I will now kindly, my lord, may I just show the facts in Booz Allen for a minute? You gave it to me.
But in fact, even in mortgage matters, outside of
My lord, it is
mortgage is another situation where it's erga omnes. Mortgage suit, for instance, has come out for testing, and Booz Allen, in a typical mortgage situation, Supreme Court has held, because mortgage thereafter leads to subsequent interests of third parties, it can only go before the civil court, because that is why from transfer of property, it is now culled out and put in CPC. Mortgage is a separate chapter in CPC. Therefore, there are situations outside of these 4, and Vidya Drolia that my learned friend has quoted in para 25 of his petition, Lordship Messi, para 25 of his petition.
1 second, I will come back.
Lordship,
wait.
May I trouble your lordship to kindly see Booz Allen for a minute, my lord?
Yes.
Well, would your lordship be kind enough to turn to paragraph number 37 of Booz Allen? It is at report page 547, and in the compilation that has been given to your lordships, my lord.
A running page?
My lord, it is at page 1. It begins at page 117. I'll give your lordships the running page of the paragraph number, my lord, that I'm referring to.
Compilation.
My lord, 132, my lord.
1 minute, Mr. Compilation.
Oh, Kodi. I'm sorry, sir.
No,
I'll give it to you, sir.
Thank you.
Para 37.
I make a submission. If the lordship is hearing on the main matter, your lordship may fix a date It's the proper procedure.
Till then ಹಂಗಾರೆ ಅಲ್ಲಿ ಏನು ಮಾಡಬೇಡಿ.
ಅಲ್ಲ
ಇಲ್ಲ ಇದೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದೆ ಸ್ವಾಮಿ
ನಾವು
ಇದೆ
stay
ಇದೆ ಇದೆ ಇದೆ
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಅದರಿಂದ ನಮ್ಗೆ ಏನಂದ್ರೆ ಒಂದು
In fact, it is an interesting question, my lord, that requires to be resolved at the hands of this honorable court.
Yes,
One way or the other, my lord, whatever the situation is.
No other high court has decided this.
No, my lord.
And we are happy
Joshi
to
called
argue
it.
before your lordship, particularly this matter. We are happy to argue before your lordship.
You should be happy to argue before every judge of this court. All they are appointed by presidents of country.
State will fix it, your lordship.
There are many more efficient judges than at least
No,
me,
I am not
not my brother.
classifying like that, your lordship.
Chandan
A
Gowdaru,
judge to us, my lord, is the court.
Nagprasanna, Chandan Gowdaru, ನಮ್ಮ ಸಂಜಯ್ ಗೌಡ, ಎಕ್ಸಲೆಂಟ್ ಜಡ್ಜಸ್ ಇದ್ದಾರೆ ನಮ್ಮಲ್ಲೆಲ್ಲ. ಏನಿಗೆ so many judges I can go on quoting. They are all best judges.
No, my lord.
ಎಷ್ಟು ಫಾಸ್ಟ್ ಇದ್ದಾರೆ ಅಂದ್ರೆ ನನಗೆ ಅವ್ರ ಜೊತೆ ಫಾಸ್ಟ್ ಹೋಗಕ್ಕೆ ಆಗೋದೇ ಇಲ್ಲ.
My lord, in defense of what my learned friend said, to us, my lord, judge equates with the court.
But
He said-
that ideally speaking true, but when we were lawyers, we used to choose the judges also. A lighter mean, I'm saying. A lighter mean. ಏನಾಗ್ತದೆ, the Cardozo says, Cardozo in his judicial process says, the ultimate decision is made in the rock bottom of the mind. In support of that decision, jurisprudential reasoning starts. Therefore, pro-labor judges, pro-tenant judges, pro-women judges,
Labor judges,
Labor
pro-management
judges.
judges. Happens,
these things
my lord.
happen.
After all, my lord, a judge is a human being. For example, my lord, if
He should be actually.
he should be, my
He
lord.
should
For
be more
example, my lord,
human being.
For
Actually.
example, my lord, we know, my lord, that there were certain pro-tenant judges. And I was asking myself, why are they pro-tenant? Is it a bias? My lord, after all, if during the younger days, they have seen a very oppressive, unreasonable, cantankerous lad walk in and throw away the things from their house, and they have seen, my lord, the women and old people in their house stand in the street.
ಏನಾಗ್ತದೆ, ನಮ್ಮ ಅನುಭವಗಳಿದಾವಲ್ಲ,
Yes.
ನಮ್ಮ ಅನುಭವಗಳು ನಮ್ಮ ಪರ್ಸೆಪ್ಷನ್ ಅನ್ನ ಕಲರ್ ಮಾಡ್ತಾವ.
It's natural.
ಆ ರೀತಿ ಆಗ್ತದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಇನ್ ಒನ್ ಸ್ಟೋರಿ ವೇರ್ ವೈ ರೆಡ್ ಈಸ್ ಡೇಂಜರಸ್ ಅನ್ಕೊಂಡು ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳ್ತಾರೆ. ಅವಾಗ ಫ್ರೈಡ್ ಹೊತ್ತಿಗೆ ಒಬ್ಬ ಮದರ್ ಮತ್ತು ಚೈಲ್ಡ್ ದೇ ಕಮ್. ಫ್ರೈಡ್ ಆ ಚೈಲ್ಡ್ ಅನ್ನ ನಾರ್ಕೋ ಅನಾಲಿಸಿಸ್ಗೆ ಒಳಪಡಿಸ್ತಾನೆ. ಅವನಿಗೆ ರೆಡ್ ಅಂದ್ರೆ ಕಂಡ್ರಾಗಲ್ಲ. ಆಮೇಲೆ ಲಾಸ್ಟಿಗೆ ಹೋದಾಗ ಏನ್ ಬರ್ತದೆ ಅಂದ್ರೆ, ಒಂದು ಕೆಂಪು ಕುದುರೆ ಒದ್ದಿರ್ತದೆ ಅವನಿಗೆ, ಮಗುಗೆ. ಅಲ್ಲಿ ಒಬ್ಬ ಬ್ಲ್ಯಾಕ್ ವುಮನ್ ಹೂ ಆಸ್ ದಿ ಗವರ್ನೆಸ್, ಅವಳು ಆ ಮಗುನ್ ಉಳಿಸ್ತಾಳೆ. ಹಂಗಾಗಿ ಬ್ಲ್ಯಾಕ್ ಕಂಡ್ರೆ ತುಂಬಾ ಪ್ರೀತಿ, ರೆಡ್ ಕಂಡ್ರೆ ಭಯ. ಪ್ರಿಜುಡಿಸಸ್ ಹಂಗೆ ತಯಾರಾಗ್ತದೆ. That way.
Now that you have mentioned about red, my lord, I want to just place one incident and then leave it at that, my lord, without detaining your lordships in the morning. My lord, Justice Bhimaya was sitting in one of our courts, my lord. Of course, I had not yet started practice. He was sitting, my lord, and hearing MVC MFS. And then, my lord, it was a case involving a BTS bus. And then the case was that there was rash and negligent driving on the part of the BTS bus, which was red in color. So
Change
he
the
said,
colour.
you should be careful of two things in red. One is the Honorable High Court of Karnataka, and the other is the red bus.
I only say that judge was very
Yeah, that was, he meant it humorously.
not truthful.
No, no, he was being humorous, just a lighter side.
Very well.
Not that. No.
After all colors, ವಿಬ್ ಗ್ಯಾರ್ನಾಗ ಇರೋದು ಎಲ್ಲ ಕೆಂಪು, ಕಿತ್ತಳೆ, ಹಳದಿ, ಹಸಿರು, ನೀಲಿ, ನೇರಳೆ, ಊದಾ, ಎಲ್ಲ ಕಲರ್ಸು ಬೇಕು ನಮಗೆ ಅಲ್ವಾ? That's how rainbow is formed.
CPC in England, as your lordship knows, my lord, is white book.
That's what. There is blue book also.
Blue book.
And there
I
are
think red book is criminal procedure.
that book. But in psychology, Carl Gustav Jung, his books are called red book, black book, white book, like that. He has given his experiences. Someday, when you get time, we know we are very extremely busy. Just turn its pages. We'll be afraid what he says about man. Yes, he has given that red book, black book, like this. He has made books of his experience. A great psychiatrist, psychologist, Carl Gustav Jung,
Yes.
a Freudian Wittgenstein.
Anyway,
well, which
consider
date
a
you
date,
want?
my lord.
Date.
Rule 10 surplus 2, my lord, to include, I'm the landlord, my lord.
You are the landlord. ಏನು ಅವ್ರು ಮಾಡ್ಕೋಬೋದನ? ಬರ್ಲಿ ಅವ್ರೇನು, it will be adding some more ideas to it. But we will hear you. You need not be allowed application, but I will hear you. All right. Here, Marnant. Okay.
Interim order to be expected.
Interim order to
Right.
continue. Call this matter. Which date?
Would your lordship consider, my lord, having it on 12th or 13th?
ಅಲ್ಲ ಈ
30.
ಒಂದು
Or
ಮೂರ್ನಾಲ್ಕು ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
March.
ಹೊರಡ್ರು ಒಂದು ದೊಡ್ಡ ಕೆಲಸ ಹಚ್ಬಿಟ್ಟಾರ, ಒಂದು 2-3 ಜನ ಸೇರ್ಕೊಂಡು ನಮ್ಗೆ ಒಂದು ಹೆವಿ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ಇಟ್ ಈಸ್ ಟೇಕಿಂಗ್ ಮಚ್ ಆಫ್ ಅವರ್ ಟೈಮ್. ಹಂಗಾಗಿ ವಿಲ್ ಹ್ಯಾವ್ ದಿಸ್ ಇನ್ ದಿ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್.
5th or 6th of March, as it puts your lordship.
5th of March.
Great.
Interim order to
Much
continue.
obliged.
We have so much to learn from people like you. Every day, if not every hour, we go on making value addition.
That's our, no, no, it's, I think, both ways. Every time we come here, we also learn so much, my lord. But, and I must tell you, lordship,
Particularly.
after all, how many cases do we as lawyers handle a day, my lord? We may handle at the most 5, 6, but your lordships handles hundreds every day.
Hundreds of
And
cases.
the exposure that your lordships have as a judge, my lord, I don't think we as lawyers can claim that.
You
my lord.
also.
Claim that.
Yes.
Great.
For the respondent.
I pray for 2 weeks' time, my lord.
2 weeks time you want? For what?
Your lordship, I have to file application for amendment, my lord.
ಅದು ಏನೋ ಒಂದು 359 ಡೇಸ್ ಡಿಲೇ ಇದೆ ಅಲ್ಲ,
Melons, Muddama Manoram.
ಟರ್ಮ್ ಮೇಲೆ ಇಡೋಣ.
Muddana Manoram.
ಮುದ್ದಣ ಮನೋರಮೆ. ನಾವು ಒಳ್ಳೆ ಪಾಠ ಇತ್ತು, ಮುದ್ದಣ ಮನೋರಮೆಯರ ಸಲ್ಲ.
I am not able to find a copy. If my friend finds, I want one copy from him.
You give that ಮುದ್ದಣ ಮನೋರಮೆ. It's a very good book. Famous statement ಗೊತ್ತಿದೆಯಾ?
So, come textbook a little less.
What was the famous statement of ಮುದ್ದಣ? ಮುದ್ದಣನ ಹೆಂಡತಿ ಮನೋರಮೆ.
Manorame.
ನೀರಿಳಿಯದ ಗಂಟಲೋಳು ಕಡಬಂ ತುರಿಕಿದಂತಾಯ್ತು. After seeing his speeches. ಕೊಡಿ ಮುದ್ದಣ ಮನೋರಮೆ ಕೊಡಿ. 2 ಕಾಪಿ ಕೊಡ್ಬೇಕು. ಒಂದು ಲೈಬ್ರರಿಗೆ 2, ಒಂದು ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. 3 ಕಾಪೀಸ್ ನೋಡಮ್ಮ. ಕಂಡೌಟ್. Yes.
Melons, what is the reason why he's saying appeal ali mistake agide? He is factor of some other case. I have no, my lords may permit him to, because order namdu
Application.
rounds ಬೇರೆ ಏನೋ ಇದೆ ಅದಕ್ಕೆ.
Application ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಿ.
Delay ಮಾಡಿ.
Not
3 weeks it may be adjourned.
all right, 3 weeks. Okay. 2 ಇದಾವನು?
2 ಇದೆ.
ಅದ್ರಲ್ಲಿ ಒಂದು ಯಾವ್ದಾರ ಬೇರೆ
2 connected ಮಾಡಿ.
ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಇದ್ರೆ ಏನಾಗ್ತವೆ? ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಬೇರೆ 2 ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅಲ್ಲ, ಮತ್ತೆ ಬೇರೆ ಒಂದು 2 ಬುಕ್ ಕೊಡಿ. ನಮ್ಮ SG ಸುಂದರ ಸ್ವಾಮಿ ಅವ್ರ ಮೇಲೆ ಒಂದು ಒಳ್ಳೆ ಬಯೋಗ್ರಫಿ ಬಂದಿದೆ, ರಾಮದಾಸ್ ಬರೆದಿದ್ದು, ಅವ್ರ ಮಕ್ಕಳು ಬರೆದಿದ್ದು, ಅದನ್ನ ಕೊಡಿ. 2 ಒಳ್ಳೆ ಬುಕ್ಸ್ ಇದೆ. Yes. Delay control.
Your lordship,
Delay control.
your lordship, transfer pricing issues are involved. Question
No,
1
no,
to 1 to 5.
Next dating.
Please.
Okay. ಯಾವುದು ಆನ್ಗೋಯಿಂಗ್ ಮ್ಯಾಟರ್ ಇದೆ ಅಲ್ಲ, ಅದರಲ್ಲಿ ಬರುತ್ತೆ ಅದು? ಅದರಲ್ಲೇ ಬರುತ್ತಾ?
ಅದರಲ್ಲೇ ಬರುತ್ತೆ.
ಕ್ವಶನ್ ನಂಬರ್ಸ್?
Question 1 to 5.
ನೋಡಮ್ಮ, 1 to 5 admitted with the following signs. Next.
Your lordship, 111 days delay, my lord. The respondent is served, my lord.
111 days delay. Delay condoned. Yes.
Respondent is served, my lord. Question on, it may be admitted. my lord.
ಯಾವ questions? ಪಡಿ.
Your lordship, question, paragraph number 4, my lord. Question 1 and 2, my lord.
One and two,
my lord.
ನೋಡಮ್ಮ, 1 and 2.
Much obliged.
Yes.
Please.
Yes, Mr. Joseph.
This matter, my lords. Prepared a 2-page short notes.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನ್ರ ಇದೆಯಾ?
Urgency.
ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನು?
The matter has been already decided by the Honorable Apex Court, my lord. The very same petitioner was before the Honorable Apex Court. Annexure L.
the order of the,
So it was dismissed.
order
Was
of
an
the
overstay
learned
in the
armed
magistrate
forces
service.
tribunal.
What is that matter? ಕೊಡಿ. ಒಂದು 15 ನಿಮಿಷ ಬೇಕಾಗ್ತದೆ. Your friends can go for a coffee walk.
Yes.
ಅಲ್ವಾ?
Yes.
ಹಾಕಿ. Yes. Start. What is that you have challenged here?
The challenge is to Annexure J, the order of the learned armed forces tribunal, my lords. It's at page 91. SLP against this order was dismissed at the SLP stage itself, and my lords, the dismissal of SLP at SLP stage does not merge with the, there is no merger effect there. Now subsequently, my lords, at page 119, if your lordship can.
This against this order you went in.
Against this order.
You went in SLP.
I filed an SLP and SLP got dismissed.
No writ petition, nothing in between
No.
for challenging this?
No, there was a dismissal of from the service, my lords. There is a dismissal certificate at Annexure E.
Yes.
That came to be challenged before the learned single judge of this honorable court. Later, they have seek.
One second, let me.
Sorry,
Yes,
sorry,
yes.
facts are-
That order was challenged. After dismissal, I challenged the order before this honorable court, writ petition number. In
So
writ
writ petition
that
came to
was-
be
That was
dismissed.
transferred to the learned arms AFT. And the AFT, after hearing me, there was only 2 sittings, my lords. And one sitting, the respondents are called upon to produce the records. There is an express order which I produced by way of a memo. Now, my lords, without calling for, without production of the records,
Where is the SLP order?
yes, SLP order, my lords, is at
Annexure
you have
L,
given-
page 117.
117.
Operative portion of the order is 118, madam. Heard on 24 to 2014.
Annexure, page 118.
No substantial question of law of general public importance arises for our
Whether
consideration.
it is on appealable or SLP it was.
Please, it was, my
No.
lords, what has happened?
Against the
Appealable-
order
an
under that
appealable order
particular
under
act.
section-
Special-
under section 30,
One second,
Juris-
please be seated. We'll come to you.
Sorry.
Come to you. Yeah.
under section 31 of the AFT Act, it is an appealable. Now,
Appealable to Supreme Court.
appealable before Supreme Court.
So you
Now, my
went
lords
in
will
appeal.
kindly see, I filed an SLP. The SLP got dismissed. Subsequently, my lords, this section 31 of AFT Act came for scrutiny before the honorable court, before the honorable Supreme Court. Your lordship gets it at page 119.
Saying,
No, the provisions of section 31 is
no,
identical.
but
to-
challenge to that order is negatived by the apex court on the ground. No substantial question of law
Actual
arises.
question of law arises.
Whether appeal is under substantial question of law? Appeal, you said, appealability under the act.
It's on a substantial, it is identical to Article 136 of the Constitution. Therefore, it came up for scrutiny, and in the proceedings, challenge to section 31 was given up, and the Honorable Supreme Court said the writ petition is competent.
Where is that? In another
Your
matter, or
lordship
in
gets
this
it at
matter?
page 119.
It was in another matter.
It was in another matter,
This matter, it operates as res judicata. It may be a wrong order.
though it's not inter-party, inter-party, but the principles of law would be,
It's inter-party.
it is not inter-party.
Why? Why do you say not inter-party?
Well, it was in case of some other case.
Not that. The one your appeal is rejected, not the SLP is declined.
Plus, my submission, my lord, says, as per this order,
Oh, let us understand the facts first. Dismissal certificate was issued to you, Annexure E.
yes, my lords.
You had put it in challenge.
I challenged it before this honorable court, and that got transferred to the AFT.
Tribunal. Defense
AFT
tribunal.
dismissed it,
Defense tribunal dismissed it.
dismissed it.
Then you took the matter in SLP to the
The
apex
SLP
court.
before the Honorable Supreme Court.
Apex court said, no substantial question of law arises, therefore, we will not entertain.
And subsequently, my lords, subsequently, the Supreme Court, I was not a party to this proceeding. At page 119, your lordship gets it.
Yes. That Purushottam Das.
Yep, please, move.
What is the law declared?
1 minute. What page 124, my lords?
124.
126. I'm sorry, 123, para 6. It was further submitted that exclusion of judicial review under Article 226 Constitution ought not to be countenanced because of lack of any viable alternative appeal mechanism. This was in turn was based on firstly Article 136(2) of the Constitution does not permit any special leave to appeal to the Supreme Court against the order of the court or tribunal constituted by or under any law relating to armed forces. Secondly, Section 31 of the said Act states that an appeal to this court would lie if a point of law of general public importance is involved. Thus, as most matters are personal to litigants being the nature of service matters and may not involve a point of law of general importance, a litigant does not have any forum for grievance or redressal except the High Court under Article 226, which it can approach aggrieved by an order of the Armed Forces Tribunal. Furthermore, the legislature were conscious of the seminality of the jurisdiction under 226 of the Constitution while drafting Section 14 of the said Act, which expressly saves the jurisdiction of the High Court from entertaining appeals arising out of Armed Forces Tribunal under Article 226, 227 of the Constitution. Now, my lords, if your lordship comes to page 120.
Because what is the law declared?
The law declared.
Writ is maintainable.
Writ is maintainable.
Correct.
Writ is
Not against your order.
Pardon, my lords?
Not this order, because it has attained finality at the hands of the highest arbitral tribunal of the country. There you should have reserved liberty.
My submission, my lords, is your lordship is aware the SLP is dismissed only with regard to grant of leave.
No, not
there is no
only that.
merger.
On the ground, no substantial question of law of general importance arises because it adopts the idea of appeal provision. Appeal provision is structured that way, like our Section 100 of CPC, 260A of Income Tax Act, Section 30 of Employees Compensation Act. That way it is structured. Nothing. What do you say?
My lords, I have filed my statement of objections on the same ground, my lords, where in the Purushottam Das case, my lords, the matter came to be remanded only on these matters. The specific words has been reproduced in the order, my lords. Thus, these matters are required to be remanded to the perspective of the High Courts, not of the petitioners. So I request this Honorable Court to dismiss the petition.
No, petitioner was not a party there.
No, my lords.
In this case, my lords, there is arbitrariness.
Writ petition is dismissed on the following ground. Petitioner's dismissal from service was put in challenge before the defense tribunal. Semicolon. The challenge was negatived by the defense tribunal. Semicolon. List was carried to the highest arbitral tribunal of the country, the apex court, in the SLP number so and so. First off, the SLP came to be negatived with the following observations. First off, the liberty is not reserved in the said judgment to litigate on the same cause of action before any court, either. First, when the highest court says no, courts below it cannot say yes. First, next one. The reliance placed by the learned counsel for the petitioner on Purushottam Das case is misconceived, to say the least. First, declaration of law is one thing, suffering of a judgment is another. First, if a judgment is structured on a wrong law, it is nevertheless an impeccable judgment. First, no merits dismissed. Next. Yes. Yes, Mr. Gunjal.
Petitioner by me. This matter, yesterday after going through the cast list of the sum court, I came to know that the vacating application has been filed by the respondent.
Or you can copy.
My lord.
ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಕಾಪಿ ಕೊಡಿ.
ಹಾಕಿದ್ದೇನೆ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು.
ಕೊಡ್ತೇನೆ, ಅದು ಇಮೇಲ್ಸ್ ಹಾಕಿದ್ದೆ. ಹ್ಯಾಂಡ್ ಓವರ್ ಕಾಪಿ, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ.
Raise
ನೆಕ್ಸ್ಟ್
time
ವೀಕ್
to
ಹಾಕೋಣ.
file objection.
ಕೊಡ್ತಾರೆ, ಕೇಳಿದ್ರೆ ಕೊಡ್ತಿದ್ರು ಅವ್ರು. ಏನು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬೇಕಿಲ್ಲ ಅವರಿಗೆಲ್ಲ. ಇಫ್ ಯು ಆಸ್ಕ್, ವಿಲ್ ಗಿವ್ 1 dozen ಅಪ್ಲಿಕೇಶನ್ಸ್.
The interim order may be extended.
Interim order
Date may be
continue.
fixed. Yeah, if there is any grievance, date may be fixed.
The issue is this one, whereas they have not to pay some amount. They have subjected themselves to the consumer.
ಅಲ್ಲಿ ಡೇಟ್ ಹೇಳಿ ಮುಂದೆ ಆರ್ಡರ್.
Next week.
ಯಾವ ಡೇಟ್ ಇತ್ತು ಅಂತ ಹೇಳಿ.
I'll serve it today itself, my lord. Let
But-
me call in the next week.
ಹಾ, 4th of February.
Hello, 6th minute.
4th ಬೇಡ. 4th ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ನಿಮ್ಗೆ. 11th of February.
11th.
ಕಾಪಿ ಕೊಡಿ. ಹಾ,
Hearing it.
ಆಯ್ತು ಹೇಳಿ, ಯಾವ ಡೇಟ್ ಹೇಳಿ, ಇನ್ನೊಂದು ಹೇಳಿ. ಇನ್ನೊಂದು ಹೇಳಿ, ಡೇಟ್ ಹೇಳಿ.
11th I've got 2 hearings.
Whichever date you want, we'll give you. 12th.
Much of it.
All.
Interim order.
Entry to continue till next date. Yes.
Lord, very short point. What has happened is 2010, I'm the owner of a property, entered into a joint development agreement. Within 30 months, he has to give me, my lord, my share of 43%. He has to take 57%.
He is a landowner.
My lord, he is the builder.
You are the landowner.
I'm the owner. Now, my lord, what he does is, he completes his building, sells all the portions, my lord, 57%. Nandralli building a complete madadilla, handover madadilla. I went before the arbitrator. Arbitrator, my lord, directs him to, my lord, complete the construction within a reasonable time. A reasonable time is to helilla. One application hakadvi. Please define what is reasonable. Award was passed, my lord, in 2023, May 2023, page 121 alli ide.
May 23.
May 16th of May 2020.
Your application was to fix the time period.
ಅಷ್ಟೇ. ಅದನ್ನ learned arbitrator says, sorry, ಅವ್ರು ಕನ್ಸಲ್ಟ್ ಮಾಡಿದ್ರೆ ನಂಗೆ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. 23 my lord, 16/5/2023 my lord, that order same day. ಇಲ್ಲಿ ತನಕ ಏನೂ ಆಗಿಲ್ಲ. ಅವ್ರು ಅದ್ರದ್ದೆಲ್ಲ ಮಾರಿದ್ರು, ನಾನು ಹೊರಗಡೆ ಇದ್ದೀನಿ, 1 inch square foot ಬಂದಿಲ್ಲ ನನಗೆ. We have filed a writ petition saying that, fix the arbitrator should have fixed a time. ಅಷ್ಟೇ, ಇಷ್ಟು ದಿವಸದೊಳಗೆ 3 ತಿಂಗಳು 6 ತಿಂಗಳು ಎಷ್ಟು ಒಂದು ಮಾಡಬೇಕಾಗಿತ್ತು. Exceptional circumstances ಅಲ್ಲಿ Supreme Court has held that, my lord, writs are maintainable against awards or interim orders of the awards passed by the arbitrator. This is the short
Respondent number 1, if I may be permitted to submit, my lords, I'm filing a memo of retirement for respondent number 1.
You are retiring from case.
Yes, my lords.
ಬಟ್ ಇದರಲ್ಲೇ 1-3 ತಿಂಗಳು ಹೋಗಿಬಿಡ್ತದೆ. ಈಗ ನೀವು ಯಾರಿಗಾರ ಒಬ್ರಿಗೆ ಇನ್ನೊಬ್ರಿಗೆ ಹೇಳಿರ ಅವರಿಗೆ?
My lords, we have informed the respondent number 1. My lords, the last matter was, no, my lords, the same matter was listed last on February 2nd, lords, 5th February last year. My lords, we have retired in July.
ಬರ್ಕೊಳ್ಳಿ. Counsel on record seeks leave of the court to retire from the case. First off, memo reads as under. First off, issue emergent notice to the respondent, returnable within 1 week, within 10 days, within 10 days. Please, first off, after appearance of the respondent, the request for retirement would be considered. First off, in the meanwhile, it is open to the respondent to make alternate arrangement for representation. Okay. Great. But returnable. ಅಲ್ಲ, ಹಂಗೆ ರೀಸನೇಬಲ್ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಅದು ಏನು? ರೀಸನೇಬಲ್ ಈಸ್ ಲೈಕ್ ದಿ ಚಾನ್ಸಲರ್ಸ್ ಫುಟ್. ಇಟ್ ಮೇ ಬಿ 9 inches to 13 inches.
Always say this, my lord. Equity license put the chancellor at ಇದೆ. Depending on his size, my lord, the equity varies.
At least ಒಂದು period fix ಮಾಡಿದ್ರೆ would have done. But how writ is maintainable is also an issue which you may
My lord,
argue.
there are 2 judgments, I'll give you a lot.
That's it.
ತಾವು ಕಾರ್ಡೋಸ ಹೇಳಿದ್ರಿ, ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಬರೀತಾರೆ in the judicial process. Experience of the judge itself, my lord, percolates in the cauldron of the decision-making process. Many things come into it, his own philosophy, his own personal experiences.
ಹಂಗಾಗಿ ನಮ್ಗೆ ರಿಯಲ್ ಸತ್ಯದ ದರ್ಶನ ಆಗುದೇ ಇಲ್ಲ.
ಹೌದು.
ಸತ್ಯ ದರ್ಶನ ಆಗ್ಲಿಕ್ಕೆ ಇವೆಲ್ಲ experience,
ಬರುತ್ತೆ.
they color our
My lord, if it is
ideas.
not, then my lord, he is not a human being. Please, my lord.
Yes.
Advocate on record.
Yes, Mr.
Weeks time.
Mohammed.
Advocate record week.
ಏನದು ಸ್ವಲ್ಪ ಹೇಳಿ ನೋಡೋಣ ಚೆನ್ನಾಗಿದ್ರೆ ಏನು ಕೊಡೋಣ ತಿಳ್ಕೊಂಡು ಟೈಮ್ ಕೊಡ್ತೀನಿ.
I'm not advocate on record.
ತೆಗೀರಿ ನೀವು just open it.
I'll
You
none-
have the file ಅದೇನು
None
constitutional
will
law
file.
ಇಲ್ಲ.
This is not that case
Huh?
file. I'm the proxy counsel because he is unwell, so he asked me to
All right.
take 1 week's time.
Call after 2 weeks
He has to produce the documents also.
on the request of counsel for the petitioner. Next.
Great.
This is Supreme Court remand matter transfer pricing question number one and
We'll
two.
let me that one. ನೋಡಮ್ಮ questions same. ನೀರಲ್ಗಿ
This matter was next week, next Wednesday.
next Wednesday, not ready today.
ಸ್ವಲ್ಪ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಇದೆ ಫಾರಿನ್ ಟ್ರೇಡ್ ಪಾಲಿಸಿ ಸ್ವಲ್ಪ ತಮಗೆ
Next week ಹಾಕೋಣ.
ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್ ಇದೆ.
Week after next. All.
We'll also make a compilation.
All.
Much.
Week after next, at the request of.
Lordship, I have raised two questions in this case. Now, transfer pricing order has been quashed by the tribunal on the ground that it is not in accordance with the circulars issued by the board. It is contrary to that, my lord. Your Lordship, my respect to submission, if that if the transfer pricing order is bad in law, whether the addition made in the transfer pricing officer, can it be, the materials gathered by the transfer pricing officer can it be ignored? And the next question is that under section 292B, this is a curable defect. Two questions have raised, my lord. There are no direct decisions on this point.
Requires consideration. You have a very fair lawyer.
Please.
Very fair and efficacious also. Radama, admit. Sides.
Lordship, another one, 28 and 29 are connected, my lord. Another one matter 654 of 23 has to be linked, my lord. It has
Call
to be
along with 654 of 2023
after 2 weeks, my lord.
after 2 weeks. 28, 29, Thane?
Yes, my lord.
All right. 31.
Your Lordship, I have raised two questions, my lord, whether the conditions for invoking section 36(1)(2) is satisfied or not. Lord, and also said next question relating to.
Hello. Those questions will arise. Nodama. Admit. Sides. Next, please.
Lordship, today only I have served the copy, my lord. Let it be adjourned for 2 weeks.
Yes.
All right, 2 weeks. Yes. Vikram,
Additional AG is appearing in this matter. Might be fast forward.
password Madaka.
I think additional AG is appearing and Mr. Chinappa appears on the other side.
All right. Password?
Yes.
Number 33.
Ah.
There's been one development.
Ah.
So now the 75 acres of land that belonged to the company in liquidation. Now what has happened is that was mortgaged to the bank. Now this 75 acres is sought to be allotted to a university. The university has given us a proposal day before yesterday for the bank to consider. So my request would be that some time may be granted for us to consider that proposal.
You are for appellant.
I'm for respondent number 2, bank.
Can
Canara Bank.
respond bank. Kiran is also come. Kiran in.
Actually, previously, my lord, there were talks of settlement. I can convince the state to accept it because it's a win-win situation, my lord. Large extent of land, which is about 75 acres of land, now in midst of Bellary town, my lord, was granted in the year 1963.
It appears you came running to the court.
Sorry, my lord.
Please be seated. Good. Next order.
No, Lord,
No problem?
yes. Lord, now the issue is, my lord, now the Honorable Supreme Court has framed about 9 questions which now this honorable court is required to answer, my lord. So we have filed our synopsis, both the parties have filed dates and events as well as synopsis, my lord. But the land is left unutilized because the company, that Bellary Spinning Mills, my lord, stopped its operation right from the year 1983. 83, my lord. It's our contention that only leasehold rights was given to the company if the general and special conditions are seen, my lord, under 1963 order. where the
Ownership was not given.
Absolute right or title in the property was not given, my lord. And permission was taken from the deputy commissioner in order to raise loans of 20 lakhs, my lord, for establishing the factory. And the deputy commissioner says specifically that land will not be mortgaged with possession. Whatever limited right that the company has,
Whatever limited interest the company
interest
has,
that the company has, my
is
lord,
permitted to be
mortgaged and raise a loan, my lord. So the company, as a security, mortgaged the land and borrowed 20 lakhs. And the bank subsequently paid other amounts as loan to the company without taking any specific permission, my lord. Now, the winding up petition was filed by the bank in the year 1984, my lord. Prior to winding up petition being filed, my lord, the state government issued a notice saying that there's a violation of the breach and conditions of the grant, and inquiry was sought to be held, my lord. Then subsequently, the winding up order was passed, and then the learned company judge, my lord, held that the company,
the property of the other side.
no, my lord,
No.
held that the company does not have absolute title to the property.
Property.
That was the finding of the learned company judge, and passed the winding up order, which was confirmed by the division bench also. Then thereafter, the bank files an application before the company court, my lord, seeking that the state does not have the power of resumption, and now it is be subject matter of jurisdiction of the company court. Permission of the company court is required to be taken, my lord. The learned single judge allows the application filed by the bank and dismisses the application filed by the state where we sought for resumption. In division bench, the learned single judge order was set aside. And in fact, directions was given to take resumption of other lands which was not subject matter of show cause notice. Then the Honorable Supreme Court sets aside and remands the matter back.
9 questions.
Framing 9 questions. So only question today, my lord, before your lordship, since we are contending that if the terms of the special conditions are perused, my lord, then it shows that since they were required to give ground rent to us and they have never paid that ground rent, we have pointed out list of breaches that the company has committed. Now today bank wants to step into the shoes of the company to say that there is no breach, which I seriously say that there is no locus, my lord. And what would be the effect of the finding of the company judge, where the company court says at the time of adjudication, now the
Binds the bank.
that binds the bank, my lord.
Bank claims under the mortgage.
That's all, my lord. And with the specific terms and conditions imposed at the time of the grant, it is only to be utilized for the purpose of spinning factory. So even if it is auctioned today, my lord, it has to be utilized for the same purpose. Plus, the state is now requires the land for its own use, my lord. There were talks of settlement where we said that an acre of land can be given to the bank, my lord, and some payment of about 8 crores was what was agreed upon. Then subsequently, I think it has fizzled out, my lord. They have taken time to get back whether the bank is agreeable to those proposals. If they say so, my lord, then I can reach out to the officials here and then make an honest attempt to see if it can be settled. But time has also been taken on this ground time and again, my lord. So my only request is, as a last chance for the bank to come back, my lord, and matter may be fixed to here.
It's a scenario, my lord, where there's a university which says that the government has agreed to give that land to the university. And there appears to have been some discussion or negotiation with syndicate bank as it then was, because this is a syndicate bank loan taken over by Canara Bank now. And the officials, at least a letter from the university says that in the discussions, the syndicate bank had come forward to accept a proposal of something of this kind, where they were supposed to pay 8 crores to the bank and 1 acre of land and 2 crores to the official liquidator to settle the dispute. Now, Canara Bank by itself, Lord, is of course a little taken aback because they don't know the officials are different. Therefore, maybe, my lord, we can examine it because ultimately we should find a solution for this issue, my lord. There is a liability which nobody can deny. And secondly, by virtue now of the order of the Supreme Court, which lays down those 9 questions, there seems to be, my lord, a little larger analysis which may have to be done than simply saying that this learned single judge has said this, because it is in the course of admitting a winding up petition or passing an order winding up, saying the argument there was, no, but of the petition of the respondent was, they already have security. So there's no, you should not wind up because you can sell the security and dispose it off, to which the learned company judge seems to have been made an observation. I wouldn't say it is really a binding dicta of the court, saying, well, it does not appear to be an absolute title, and therefore that argument also is not available to the petitioner. That is really what happened, which afterwards, not the proceedings we initiated asking for result that they cannot resume because
Anyway, now
in
battle
the
lines
custody
are
of the
drawn
court.
up. Now battle lines are drawn up with the questions drawn by
Framed
the
by the
apex court.
Supreme- Yes.
Those questions we
Those
can,
questions have to be answered,
answer.
which will require your lordship
We
to
have
also
also
examine.
filed synopsis answering all those questions.
No, I'm saying which necessarily now requires your lordship to also examine under which provision of the law this grant was made, because nobody seems to know. The grant order
Now,
doesn't say so.
For that, no much time is required. Where no law is brought out, then there is Government's Grant Act 1897. It is relatable to that. There are some judgments.
Yes,
to that.
Government Grants Act 1898 actually is, if I may say so, an exception to the Transfer Property Act. Only 3 sections.
State grants are covered.
Yeah, it says all grants made by the state, which otherwise doesn't comply with the requirements of Transfer Property Act. Your lordships remember remembers the section. It's a 3-section act, which actually acts as an exception to the Transfer Property Act, because registration is not required, but registration is mandatory otherwise under Transfer Property Act.
No, for state it is not required.
That's what I'm saying. So the Government's Grants Act makes that exception, saying any grant made. And that, of course,
I think matter is to some extent covered by apex court. Very long ago, I read Haji ke Kutti Naha versus so and so, where government considered the apex court considered the effect of the Government Grants Act.
Let's look at that. I'll take a look at that one. I think maybe your lordships can.
But I remember that name is very,
Yes,
this one. In fact, I do not know, but there are such judgments.
Yes.
The Government's Grants Act. Yes, government has got power to grant lands, and such grants shall be treated as legislations. Yes, that's how they have said.
It's a fascinating piece of legislation because only 3 sections, and 1 section not covers everything that is to be said.
Correct.
It's very beautifully written.
Rule against perpetuity.
No, not perpetuity, but
All other registration, idella
Or
ಬೇಕಾಗುತ್ತೆ.
even otherwise, my lord, state government is entitled in exercise of its executive power
Power
also.
also.
no.
To grant-
We are relating it to a particular.
This is the act which
Yeah.
I mentioned.
This is section 2.
How could you, you did not consult me in the morning today.
No. The Supreme Court notices it in the order. Please see section 2. Nothing in the Transfer Property Act contained shall apply
We
or be deemed ever to have
any
applied
grant.
to any grant or the transfer of land or of any interest therein heretofore made or hereafter to be made by or on behalf of the government to or in favor of any person whatsoever. For every such
ಅಲ್ಲಿ
grant
shall be, transfer shall be construed ಆಗಬೇಕು.
construed
Print ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ.
and take effect as
Construed
the
and
said
take
act
effect as if the said act had not been
been passed.
passed.
This is almost like saying that every grant will, which, but in this case, not there is one enactment.
Section 3.
Yes, section 3. All provisions restricted.
Mostly the smallest act it may be, barring Hammurabi's code. And Democles sir, he has enlisted all the offences and said for all these death penalty.
Correct. All provisions restrictions.
All provisions, restrictions, and condition limitations contained in such grant or transfer as offers shall be valid and take effect according to their tenor, any rule of law. The contrary, notwithstanding, it takes as, therefore Supreme Court said in Haji K that it takes as if it is a legislative act ಅಂತ hold ಮಾಡಿದ್ದಾರೆ.
Then Karnataka brings in its own enactment to extend the provisions of the government's grant.
It is adopted by
Extension.
Karnataka.
But that was in the year 1978,
72.
72.
But the extension, what happens is, because it says heretofore made or hereafter to be made. Therefore, it retrospectively
It
protects all
covers
grants.
everything.
It ever covers everything. That is it. What else?
Heretofore made
Heretofore made or
or hereafter to
be
be
made.
made.
So it is automatically retrospective.
No, this act is retrospective, but adoption by the state government.
Will
What
apply,
happens?
will
Whether
apply,
that will be
yes,
retrospective is
it
the
will be
question.
because it applies that entire provision as it is through the Karnataka Act. So it practically is heretofore made or hereafter to be made.
Which Karnataka Act made adopted? This is by adoption.
No, it's a government grants Karnataka Extension Act 1972. Section 2, also a
Does not say with retrospective effect. No? What do you say? No, but where does it say?
When
This was reserved for the assent of the president on the next page. Your lordship turns over to the page.
hereby extended to and shall be enforceable.
In the whole of Karnataka.
Means with retrospective effect will come.
Yes, my lord, because by
What is how courts have interpreted this provision?
this, I don't think there's ever been an interpretation in Karnataka, but I'll tell you lordship what I understand from this.
That act is retrospective.
That act is retrospective.
Once a retrospective act is implemented, the implementation act should also be retrospective is your submission.
Yes, and it has to be, my lord, in my humble submission, because otherwise, by the time the 1972 Act came, there are several grants which have been made in Karnataka. So if all
they will
of
be
them are
excluded.
contrary to the Transfer of Property Act. Therefore, by simply applying it, it automatically protected every grant which was made.
Appears to be that way.
Well, insofar as cashew cultivation is concerned, there also by virtue of an executive order, the grants were made.
Independent of all these, the government has power to transfer the property. It has power,
yes,
to transfer the property. But question is whether Transfer of Property Act would be applicable or not. Power to execute, you may have power of attorney.
Yes.
Power to execute is one thing, because you are owner. Someone says the ownership is a bundle of rights. One of them is power to transfer. So you will have power to transfer is true.
Yes.
But in the absence of this act, the Transfer of Property Act, maybe Registration Act may not be, Stamp Act also may not be.
Will not
But
apply.
Registration Act will be, the Transfer of Property Act would be applicable. Because 63 or 64 Supreme Court. Calcutta City Corporation versus Legal Remembrancer. Something like that is one judgment, very famous judgment, sir, where the first view was the state is not bound by the laws because state is the giver of laws on the unless law itself says state is bound. That is reversed by the Constitution bench of the Apex Court in 1960s. Maybe that I was not born, certainly both of you were not born. He was perhaps. There, Aditya, can you work out that? Legal Remembrancer versus City Corporation, something like that. Very beautifully argued matter. They said, statute shall apply to the state unless it says otherwise. The proposition came to be reversed. 63 or 64? 66, maybe. Correct. That's the judgment. Hangagi, Transfer of Property Act will be because Section 5 defines transfer. And under the General Causes Act, state is also a person.
This is before the board.
Yes, state is a corporate entity. It's a corporate entity. Very beautifully, there is a discussion by Harsh Luterpart, a judge of International Court of Justice. He treated what is a state, what are its characteristics. In fact, Samand also says, state is a mega corporation in his 12th edition, Fitzgerald's edition. It is said that way. And one judgment you may look into. The state can do all that the statute authorizes to do. A natural person can do all that the statute has not prohibited it from doing. This is the difference. The very famous judgment of Calcutta High Court, a division bench judgment of Calcutta High Court, AR 1948 or 49 Calcutta, which you have referred to in hijab judgment.
Yes.
The limitation is this: a legal person, state is a legal person. It's an entity constituted under the Constitution itself. A legal person can do only that which he is authorized to do by the instrument. A natural person can do all that which is not prohibited by law. Everything is open to him.
Like
Very
fundamental
beautiful,
rights.
very beautiful.
That, like fundamental rights, my lord.
No,
All rights which are reasonably restricted can be exercised.
That's that way.
Start from the position that the Crown was exempt.
Correct. Crown was exempted.
And then it says that however in a federal constitutional structure, that presumption does not carry forward at all.
Correct.
And therefore it says.
Now, Crown was exempted in England because the Crown Proceedings Act 1947 was enacted. There is a Crown Proceedings Act 1947. Therefore, they say Crown is exempted. But we don't have such thing. This one. There the Supreme Court said that the state is bound by law unless the law otherwise exempts it.
In fact, Shirvai says the fundamental rights are residuary rights. After taking away all the reasonable restrictions that the state can impose, then what are left can be enjoyed by the. That's another way that. Not here, my lord. They don't dispute the grant made in the year 1963, my lord. Now the question is whether it is lease or sale.
Is it grant? Is it whether absolute transfer of title or otherwise?
Or otherwise. That's precisely. So.
Order says alienation.
Huh?
Order says alienation.
Realization.
Alienation, word used in the order.
Alienation is a genus. Even lease is an alienation.
It is alienated and then
Correct. Alienated or bala meaning alienation is treated as a genus. There are species which 5 Transfer of Property Act section 5 identifies that sale, gift, exchange, where absolute title is transferred. Then lease and mortgage.
Only
these are all they fit into this one. We have to see what are the terms. Then we'll come to that.
Price is fixed.
Upset price is fixed
Per acre, 500 rupees.
in those days.
Alienation, upset price. Club together is almost sale only.
But if other conditions are there,
No, conditions may be there. If I violate the condition, the requirement of this thing is required to be followed by them is also the matter to be argued. But it is, telling it is only a grant, it is only a lease is not correct. That is what I think.
Now, there's a ground rent which the company was required to pay under the same grant.
therefore it cannot be
So
absolute.
it cannot be
transfer.
construed as, and there were a lot of restrictions with regard to the functioning of the factory itself.
If it was a-
Utilization of the land,
If absolute ownership was given, these things would not
all
have
this
done.
would not have been there.
What you say is, all these conditions are enforceable because section 9, 10, 11, 12, 13, 14 of Transfer of Property Act are not applicable. Going by your,
Yes.
the object of this 1897 Act
Yes.
is to exclude the operation of Transfer of Property
Transfer of-
Act. Appears to be a good point. Let us see. It's a very interesting point it is.
Now, my lord,
66, 66 ಏನದ ಹೆಸರು ಪಾರ್ಟಿ ಇದು ಕೇಸಸ್ some superintendent legal remembrancer. Remembrancer. Correct. That was the judgment which our Professor K.N. Sheshadri used to tell at about 38 years ago. Yeah. Mostly Settleward, Mr. Settleward had argued, Daptari and Settleward had argued that matter. Correct. Correct. That's not your money. Just
we'll find out, and we'll also see whether that settlement talk which occurred then, they say in 2017, we'll place it now before the board at least of Canara Bank. And then we can possibly come and say, if it's acceptable, it will put an end to this problem forever. Otherwise, we are back to your lordships to
But
answer this question.
time is taken on that front for last 3 months.
One date fixed madman.
So let the matter be fixed, my lord. In the meanwhile, if they come back, I can also explore the possibility.
Argument what time koda prashne illela. ಮತ್ ಒದಕದ್ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅದಕ್ಕೆ. Correct. ತಳಿ. ಯಾವತ್ತು ಹೇಳಿ ಆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
2 weeks from today, my lord, may I request?
Date fix ಮಾಡಿ.
No, 2 weeks.
No, they need 4 weeks, I'm told.
No, 4 weeks for the bank too. By then, my lord, they can always
But
come
when
back.
he came out, he said 2 weeks actually.
ಹೇಳಿಲ್ಲ 2 weeks ಅಂತ ಹೇಳಿಲ್ಲ. I just said that there's a proposal.
My lord, because
and that some
75
three
acres,
3 weeks.
only my request is, my lord, 75 acres has been left unutilized for ever since 84. my lord. Prime land now, it has
It's a
not
question
been
of winding
utilized
up.
at all.
My learned friend knows it's unutilized now for ever since the winding up petition is filed and admitted.
And we have
winding
issued
up has
notice,
started, there is nothing. But the notice comes in 86. not in
84, my
84.
lord.
84
First
is what
notice,
is on there.
Lord,
86.
one other aspect here is, my lord, the first notice is issued prior to the winding up petition itself. So question of the state government seeking permission of the company court also may not arise. my lord.
No, ಈಗ anyway, the battle lines are drawn now. The questions are framed by the
Yes.
apex court. On those lines, we
And
will
on all the judgments that you lordship will
ಮುಗಿದೆವು.
also prepare and come.
3 weeks time ಕೊಡ್ತೇವೆ. ಅದ್ರಲ್ಲಿ next date ಗೆ ಬರ್ಬೇಕು. ಬರ್ಕೊಳ್ಳಿ. 3 ತಿಂಗಳದ್ದು ಟೈಮ್ 3 ವಾರ ಕೊಡಿ ಟೈಮ್.
Yes.
19th of February argue ಮಾಡ್ಬೇಕು.
Yes.
Finally, no, the parties and their counsel are put to notice that no further adjournment shall be granted on any
Right.
ground whatsoever.
In fact, on order of remand, my lord, the Honorable Supreme Court says the loan of 20 lakhs or 36 lakhs has snowballed into 1,500 crores. The compounded interest haki, 1,500 crores is the amount.
Not compound, say contractual interest. Not compound.
No,
It's a bad thing.
If contract provides for compoundable interest.
Compoundable. No, but it sounds bad, my lord, when they say you're importing compound interest. But it is actually contractual interest.
Anyway, whether there is compound to the property,
I think so.
yes, property.
As of now, protected.
Yes, great. It's a pleasure to hear people like you.
Lord, whenever we come here, we go back with at least 2-3 new pieces of information and knowledge from your lordship. Every single time.
That happens to me also. That happens to me also.
Great.
Great.
Like to appear for the petition, my lords.
Yes, Kamal.
Lords, the brief facts of this case, my lord. The goods were moving from.
Aditya, are you ready in the matter?
I'm ready. 2 submissions, my lord. One is that the matter is listed for final hearing, but the questions don't appear to have been framed as per the order sheet. The
ಎಷ್ಟಿರೋ ಮ್ಯಾಟರ್ಸ್
questions frame ಆಗಿದೆಯಾ?
ಒರೇ
Admit ಆಗಿದೆ.
Admit ಆಗಿದೆ.
ಮಧ್ಯಾಹ್ನ ಬಂದ.
Questions are.
All right, afternoon you can take this matter.
But it may not take much time. Unfortunately, what has happened, there are 2 findings. One is that the dealers in Salem where the cargo was going, the goods were going, were found to be bogus.
Anyway, ನಾವೊಂದು 2 judgments finalize ಮಾಡ್ತೀನಿ.
That inspection report is-
Afternoon will come.
It may not take much time.
That's what.
It will be taken in the afternoon, my lord.
Afternoon.
Is it taken in the afternoon?
Allah, if you want, we'll give time. Otherwise, we'll take in the afternoon.
ನಾಳೆ.
ನಾಳೆಗೆ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. ಒಂದು ಡೇಟ್ ಕೊಡ್ತೇವೆ, ಡೇಟ್ ತೊಗೊಳ್ಳಿ.
So next week.
ಅಲ್ಲ. ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್. 2 week.
Next week. Same day next week. Same day. Week after next week. Week after next week.
Sitting alone ಮಾತ್ರ ಹೀಗೆ
ಇಲ್ಲ, ಇದು ನೋಡಿ, ಇದು ಮಧ್ಯಾಹ್ನದ್ದು ಅವ್ರು ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. ಅದು ಒನ್ ದಟ್ ಇಸ್ 12:30. ಇದು ಹೊಸ ಮ್ಯಾಟರ್. ಇದರಲ್ಲಿ Tirumalesh is appearing. Two points. One is on denial of input tax credit. The other is the importance of returns. I have asked the officer for one proposition notice that is not filed by the other side. You can argue without that also, but our start Monday. Next week. Okay.
Appearing for petitioner.
Vacation. Lord,
Yes.
yes, I am for the respondent. Lord, in Buda, in view of the ongoing litigations and all and irregularities and inquiries going on, for that reason, what commissioner is afraid of to take decision to allot side. Let there be a court order. We will.
The present writ petition is filed challenging the impugned order passed by the Honorable State Commission, Worship. The State Honorable Commission, by reversing the order passed by the District Consumer Commission. District Consumer Commission first. Yes, District Consumer. Deficiency in service, I have approached the District Consumer Forum initially. Order is passed in favor of me. Against that order, yes, they went to State Consumer Forum. Appeal is allowed. Lordship, one brief, the brief facts of the case is, it is the case of the petitioner that the subject matter of the site was allotted by respondent number 1 Muda under ex-serviceman category. Ex-serviceman category. 2001 nalli allotment. Annexure C, Lordship. Annexure C, page number 47 of petition, main petition. Howd son. Howd Manjurati Patra. 25/2/2001. ನಲ್ಲಿ allotment ಆಗುತ್ತೆ. The payment, the entire sale consideration is 1,60,000. I have paid 1,60,500. 500 is application charge, that is 1,60,000 house. Yes, I have paid, and in that there is no dispute also regarding the payment, regarding the ex-serviceman category. There is no dispute by the respondent number 1.
Payment on two occasions he was paid, but on the last installment at 21,930 was not paid in time. There is some 4-5 months delay. The reason for that, Malad, so we have issued notice. So he was working some place. We have issued notice to that address. So subsequently, when we issued notice to that address, by that time, Malad, he was transferred to some other place. Please. ಆ ಟೈಮಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಇವ್ರಿಗೆ ಗೊತ್ತಾಗಿಲ್ಲ, ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅಂತ ವಾಪಸ್ ಬಂತು. ಫಾರ್ ದಟ್ ರೀಸನ್ ಇವ್ರು ಆಸ್ ಯೂಶುವಲ್ ಸೈಟ್ ಅಲಾಟ್ಮೆಂಟ್ ಈಸ್ ಕ್ಯಾನ್ಸಲ್ಡ್. ಆನ್ 5/7/2014. 14. Through post, registered post. But ಇದರಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ ಆರ್ಡರ್ ನೋಡಿ that I made submission.
It's the contention of the respondent number 1 that the last installment within the prescribed, ಹೌದು ಅದನ್ನು within the prescribed time ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ನಾವು ನೋಟಿಸ್ ಕಳಿಸಿದ್ವಿ. ನೋಟಿಸ್ ನಲ್ಲಿ ಆ ಇಂಟ್ರೆಸ್ಟ್ ಅನ್ನು ನಾವು ಕೊಡ್ಲಿಕ್ಕೆ ಪೆಟಿಷನರ್ ಮುಂದೆ ಬಂದ್ರು. ಬಟ್ ದೇರ್ ಇಸ್ ನೋ ಪ್ರಾವಿಷನ್ ಅಂಡರ್ ದಿ ದೇರ್ ಆಕ್ಟ್ ಟು ರಿಸೀವ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಹೇಳಿ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ನ ಕಂಟೆನ್ಷನ್. ದಟ್ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್ ದಿ appeal is allowed, lordship. Interest ತಗೊಳ್ಳಿಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ ಅಂಡರ್ ದೇರ್ ಆಕ್ಟ್ ಅಂತ ಇಸ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್. lordship may kindly see the endorsement issued by ಹಿಂಬರಹ ಅಂತ ಇದೆ, ಎನೆಕ್ಷರ್ ಇ ನಲ್ಲಿದೆ. 52 ಪೇಜ್ ನಂಬರ್ 52 lordship. May I read that? Starting from Mysore Nagarabhivruddhi Apadik.
If in case of more number of applicants, application rejected on this ground, as sometimes as directed by the government, we condone and we accept the belated installments also, as per the direction issued by the government.
No, lordship, they are not.
ಇಲ್ಲ.
It's not registered in my favor. Interest after the knowledge of the nange alli interest kodbeku anta yavaga nanna knowledge ge bantu, immediately I have not taken steps. I have taken steps. ನಾನು ಸುಮ್ಮನೆ ಕೂತಿರ್ಲಿಲ್ಲ. ಸೊ I have taken steps and ನಾನು ಯಾವಾಗ ನಂಗೆ ಆರ್ಮೇಲಲ್ಲಿ ಟೈಮ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ನಂಗೆ ರಜೆ ಸಿಕ್ತು, ನಾನು immediately I approached the Honorable Muda, and after that there is no response. At that time also I am ready and willing to pay my part of the, if there is interest. As per my contention is that I have paid within the prescribed time limit. But even if this lordship come to a conclusion that there is the interest portion idru kuda, I am ready and
Commission reason at page 43, para 3. please. Karnataka Urban Development Authority, allotment of site rules. Rule 19. Karnataka allotment, Karnataka Urban Development Authorities, allotment of site rules.
Lordship, can I make one submission? Section 19 of the Act says clearly, it says that, and it has to be interpreted in the context. It says that adu section 19 ಯಾಕೆ ಬಂತು ಅಂತ ನೋಡಿದೆ regarding I may permitted to produce some citations in this. Yes.
Rule 90. Rule 90. Civil communities are rule, allotment of site rules. ಅದರಲ್ಲಿ ಆ ಬುಕ್ಕಲ್ಲಿ ಇಲ್ಲ.
ಕನ್ನಡದಲ್ಲಿ. ಇದೆಲ್ಲ 19 ನಿವೇಶನದ ಹಂಚಿಕೆ. ಕರ್ನಾಟಕ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನಿವೇಶನಗಳ ಹಂಚಿಕೆ ನಿಯಮಗಳು 1991. ಕರ್ನಾಟಕ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನಿವೇಶನಗಳ ಹಂಚಿಕೆ ನಿಯಮಗಳು 1991. ಹೌದು. ರೂಲ್ 19 ನಿವೇಶನದ ಹಂಚಿಕೆ ಮತ್ತು ಮಾರಾಟದ ಷರತ್ತುಗಳು ಅಂತ. ಅದು ಇಂಗ್ಲಿಷ್ ವರ್ಷನ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ
ಇದರಲ್ಲಿಲ್ಲ.
ನಿವೇಶನದ ಹಂಚಿಕೆ ಮತ್ತು ಮಾರಾಟದ ಷರತ್ತುಗಳು.
ನಾನು ತಂದಿಲ್ಲ, ಮಾಡ್ತಿದ್ದೇನೆ. ಹೊಸ ಬುಕ್ಕಲ್ಲಿ ಈ ಬುಕ್ಗಳಿಂದ ಕೆಲವೊಂದು ಎಡಿಷನ್ ಅಲ್ಲಿ ಇದೆ, ಇದರಲ್ಲಿಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಕರ್ನಾಟಕ ನಗರ ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ನಿವೇಶನಗಳ ಹಂಚಿಕೆ ನಿಯಮಗಳು 1991. ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಇಂಗ್ಲಿಷ್ ಆಕ್ಚುಲಿ ಅದು ಎಲ್ಲಿನೂ ಸಿಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಿವೇಶನದ ಹಂಚಿಕೆ ಮತ್ತು ಮಾರಾಟದ ಷರತ್ತುಗಳು. ಈ ನಿಯಮಗಳ ಮೇರೆಗೆ ನಿವೇಶನದ ಹಂಚುವಿಕೆಯು ಈ ಮುಂದಿನ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಡತಕ್ಕದ್ದು ಎಂದರೆ, ಹಂಚಿಕೆ ಪಡೆದವನು ಹಂಚಿಕೆ ನೋಟಿಸ್ ಅನ್ನು ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕದಿಂದ, ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್, ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕದಿಂದ 60 ದಿನಗಳ ಅವಧಿಯ ಒಳಗೆ ನಿವೇಶನದ ಬೆಲೆಯ 15% ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಂದಾಯ ಮಾಡತಕ್ಕದ್ದು ಮತ್ತು ಅಂತಹ ಸಂದಾಯವನ್ನು 60 ದಿನಗಳ ಒಳಗಡೆ ಮಾಡದೇ ಇದ್ದರೆ ಹಂಚಿಕೆ ಪಡೆದವನು ಹಂಚಿಕೆಯನ್ನು ನಿರಾಕರಿಸಿದ್ದಾರೆಂದು ಭಾವಿಸತಕ್ಕದ್ದು.
ಮೌಲ್ಯದ ಬಾಕಿಯನ್ನು
ನಿವೇಶನದ ಮೌಲ್ಯದ ಬಾಕಿಯನ್ನು
90 ದಿನಗಳ ಒಳಗೆ
ನೋಟಿಸ್ ಅನ್ನು ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕದಿಂದ 90 ದಿನಗಳ ಒಳಗೆ ಅಥವಾ 90 ದಿವಸಗಳನ್ನು ಮೀರದ ಅಂತ ವಿಸ್ತೃತ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಪೀರಿಯಡ್ ಅವಧಿಯೊಳಗೆ ವರ್ಷವೊಂದಕ್ಕೆ 12% ಬಡ್ಡಿಯ ದರದಲ್ಲಿ ಸಂದಾಯ ಮಾಡತಕ್ಕದ್ದು. ಪ್ರಾಧಿಕಾರವು ವರ್ಷಕ್ಕೆ 18% ದರದಲ್ಲಿ
ಪ್ರಾಧಿಕಾರವು ವರ್ಷಕ್ಕೆ ಅಂತ ಹೇಳಿದೆ ವರ್ಡ್.
ಹೌದು, ವರ್ಷಕ್ಕೆ
ಇದೆಯಾ ಅಲ್ಲಿ?
ಹೌದು ಸ್ವಾಮಿ, ವರ್ಷಕ್ಕಿಂತ ಆನ್ಯುವಲ್.
ಇದ್ರಲ್ಲಿ ಮಿಸ್ ಆಗಿದೆ.
ವರ್ಷಕ್ಕೆ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಪ್ರಾಧಿಕಾರ ವರ್ಷಕ್ಕೆ 18% ದರದಲ್ಲಿ ಬಡ್ಡಿಯೊಂದಿಗೆ 6 ತಿಂಗಳವರೆಗೆ ಅವಧಿಯನ್ನು ವಿಸ್ತರಿಸಬಹುದು. ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಪೀರಿಯಡ್ ಇಸ್ 6 months. 90 ದಿನಗಳ ಅವಧಿಯೊಳಗೆ ಅಥವಾ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅವಧಿಯೊಳಗೆ ಸದರಿ ಮೊಬಲಗನ್ನು ಸಂದಾಯ ಮಾಡದಿದ್ದರೆ ಹಂಚಿಕೆ ಪಡೆದವನಿಂದ ಸಂದಾಯ ಮಾಡಲಾದ ಖಾತರಿ ಠೇವಣಿಯು ಮುಟ್ಟುಗೋಲಿಗೆ ಬದ್ಧವಾಗಿರತಕ್ಕದ್ದು ಮತ್ತು ಹಂಚಿಕೆಯನ್ನು ರದ್ದು ಮಾಡಬಹುದು. ಬೈ ಯೂಸಿಂಗ್ ದಿಸ್ ಪವರ್, the respondent number has given endorsement to the petitioner. My humble submission before this honorable court is the site is allotted under ex-serviceman category to the petitioner. ಯಾಕೆ ಅವರಿಗೆ ex-serviceman category ಒಂದು ಸೈಟ್ ಅನ್ನು ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಅವರಿಗೆ ಬೈ ಕನ್ಸಿಡರಿಂಗ್ ಅವರ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಅನ್ನು ಮಾಡಿ, ಅಂದ್ರೆ ಅವ್ರ ದೇಶಕ್ಕೆ ಏನು ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವರ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಹೇಗಿದೆ, ಅಥವಾ ಒಂದು ಸ್ಪೆಷಲ್ ಕ್ಯಾಟಗರಿ ಅಂತ ಹೇಳಿ, ಅಂದ್ರೆ ಆ ಸಂದರ್ಭದಲ್ಲಿ ದಿಸ್ ಹಾನರಬಲ್ ಕೋರ್ಟ್ ಮೇ ಕನ್ಸಿಡರ್ ದಿ ಸಿಚುವೇಶನ್ ಅಂಡ್ my humble submission before this honorable court is that the doctrine of estoppel is initial agi they have given the endorsement. After that our reject ಮಾಡ್ತಾರೆ. It is against the rule of doctrine of estoppel is my humble submission. ಇನ್ನೊಂದು lordship, the substantial complaints, if lordship comes to a conclusion that ನಾನು ಆ ಟೈಮ್ ಒಳಗಡೆ ಮಾಡಿಲ್ಲ ಅಂತ ಬಂದ್ಕಂದ್ರು ಕೂಡ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಸೈಪ್ರೆಸ್ ಅಂದ್ರೆ ಸಬ್ಸ್ಟಾನ್ಶಿಯಲಿ ಕಂಪ್ಲೈಡ್ ಅಂತ ಹೇಳುದನ್ನು ಮಾಡಬಹುದಿತ್ತು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಗೆ. ಇನ್ನು ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಅನ್ಜಸ್ಟ್ ಎನ್ರಿಚ್ಮೆಂಟ್, I have paid the substantial portion of the amount, sale consideration, and it is again the state article 212 the MODA comes under the state, it's a authority of the government. In such a case, the doctrine of it's against doctrine of unjust enrichment and doctrine of in such a case lordship, the secondary rules of interpretation says that the doctrine of contemporaneous exposition ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಟೆಂಪರರಿ ಆಕ್ಟ್ಸ್ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ when there is the ambiguity in the statute, ಈಗ ಇದರಲ್ಲಿ ಮಾಡಬಹುದಾ ಮಾಡಬಾರದು ಅಂತ ಪ್ರಶ್ನೆ ಬಂದ್ರೆ ಆಗ ನಾವು the secondary rules of interpretation ಏನ್ ಹೇಳುತ್ತೆ ಅಂತಂದ್ರೆ there are some acts, the section 76 of the Companies Act ಅನ್ನು ನೋಡಿದ್ರೆ ಅದರಲ್ಲಿ ಒಂದು ಪ್ರಾವಿಷನ್ ಇದೆ ಸ್ವಾಮಿ, ಡೆಪಾಸಿಟ್ಸ್ ಆಫ್ ಪ್ರಾವಿಷನ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ಡೆಪಾಸಿಟ್ಸ್ ಬೈ ದಿ ಪಬ್ಲಿಕ್ ಅಂತ.
Yes, you argued well. Please be seated. Which is the section which refers to estoppel? Which law? Which section?
Rules of promissory estoppel. It comes under
estoppel. Only estoppel.
Evidence Act ಅಲ್ಲಿ ನಾವು.
Which section?
Evidence Act ನಂಗೊತ್ತು
115.
ಹೌದು, Evidence Act is equitable estoppel, doctrine of promissory estoppel.
No, not that. Estoppel alone is treated by Evidence Act. Estoppel means
119.
115. 115. Promissory estoppel is different from estoppel. Estoppel operates in a private law. Promissory estoppel operates in public law. Got the point? What is private law? What is public law? Again, a big debate which we will not interfere. You have to do your study. Got the point? On promissory estoppel, 2 important decisions I am telling. One is
Padampat.
Correct. Padampat Sugar Mills versus State of MP ಇರ್ಬೇಕು.
Initially government sugar factory ಮಾಡಿತ್ತಲ್ಲ.
That is reiterated in Indo-Afghan agencies versus Union of India. That's the point. I will give you further material. When in Bhopal gas tragedy took place, the case was filed in American court. And cases were filed in Indian court also. There in America, India as a party said, send this case to India, not to America. Then judges asked, why we should send? Your judiciary is not up to mark. Why we should send? At that time, Indian government filed two affidavits, one by Palkhiwala, another by J.B. Dadajanji. In Palkhiwala's affidavit, why Indian judiciary is great, he quoted Motilal Padam Bhatt in his affidavit. This you will find in the book, write down. Otherwise you will go like that only without reading. Mass Disaster and Law by Dr. Upendra Bakshi. He has produced this affidavit as an annexure to that book. This is published by Indian Law Institute. Vanella otkabek. Avaga wider acceptance irtade, wider view irtade. How doctrine of promissory estoppel arises, how it differs from estoppel. These things you will. All right. All right. Anyway, you have argued well. And you were mentioning about contemporaneo expositio.
When there is an ambiguity in the present statute, we can borrow the provisions from the other statute. Is
Not that.
Is there is any ambiguity in the, for example, if there is any ambiguity in the BD Act, ಅದಕ್ಕೆ ಕಂಟೆಂಪರರಿ ಒಂದು 3 ಆಕ್ಟ್ ಇನ್ನೊಂದು ಆಕ್ಟ್ ಇರುತ್ತೆ, ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳೋದನ್ನು ನಾನು ಇಂಟರ್ಪ್ರೆಟ್ ಮಾಡ್ಬೋದು ಅಂತ.
ಅದಕ್ಕೆ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಪಾರಿ ಮಟೀರಿಯಾ ಅಂತ. It is called doctrine of pari materia. Similar legislations. Namdu Karnataka Rent Control Act, Maharashtra Rent Control Act. ನೋಡೋಣ ಯಾವ ರೀತಿ ಹೇಳಿದ್ದಾರೆ. ಆ ರೀತಿ ಮುಖ್ಯ. The doctrine of contemporaneo expositio means law should be interpreted in a way as it was enacted centuries ago. 1862 IPC. Nobody was, those, when that law was made, none of us were born. Is it not? Still it continues to apply to us. Our consent is not there. Understood? Suppose if you want to interpret any provision of law, you should interpret provision of law in such a way that you were there when Macaulay enacted it. That is called doctrine of contemporaneo expositio. This is discussed by which is that famous Maxwell on interpretation of law. Of course, some high courts have said, as you have said, that when there is some ambiguity in the provision, other cognate legislation should be looked into that way. That may not be the correct view of the juries. Okay?
And
just look it.
I have given this honorable court judgment in 2 judgments. Writ appeal number 10.0914 of 2015.
In an identical matter? It related to which matter? That was a case relating to land acquisition. Anyway, let us see. Right? Kindly be seated.
Paragraph number 15 says that, paragraph number 15. Paragraph number 15 of this judgment. The first respondent is an octogenarian ex-serviceman and in the evening of his life, as long back as on 9/5/2008, the authority has written a letter conveying categorically that the appellants
were... Stop acquisition proceedings.
ಹೌದು ಬಟ್ ವಾಟ್ ಈಸ್ ಎಕ್ಸ್-ಸರ್ವಿಸ್ ಮೆನ್ ಕ್ಯಾಟಗರಿ ಬಗ್ಗೆ ಅಂದ್ರೆ ಅವರು ವೈ ದೇ ಆ ಟೈಮ್ ನ ಒಳಗಡೆ ಬರ್ಲಿಕ್ಕೆ ಎಕ್ಸ್-ಸರ್ವಿಸ್ ಮೆನ್ ಕ್ಯಾಟಗರಿಗೆ ಯಾಕೆ ಸ್ಪೆಷಲ್ ಕೇಸ್ ಅಂತ ಕನ್ಸಿಡರ್ ಆರ್ಟಿಕಲ್ 14 ಯಾಕೆ ವೈಲೇಷನ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ವ್ಯೂ ಆಫ್ ದಿಸ್ ಆನರೇಬಲ್ ಕೋರ್ಟ್ ಅಂಡ್ ಆರ್ಟಿಕಲ್ paragraph number 15 and ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ paragraph number 8 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
All right.
Justice Ananda Bhaira Reddy ಅವರದೊಂದು paragraph number 8 ಅಲ್ಲಿ the petitioner who is before the court has not produced any materials as regards his war record and on demand by this court to demonstrate that he had actually fought in several wars. He produced a string of medals through his counsels to demonstrate that he had participated in the 1962 war with China. The 1965 ಆ ತರ ಹೇಳಿ ಲಾಸ್ಟ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ ಇದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಸೇಲ್ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಕನ್ಸಿಡರ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ತಾರೆ ಬಿಕಾಸ್ ಅವರಿಗೆ ದ ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ದಿ ನೇಷನ್ ಈಸ್ ಮೋರ್ ಇಂಪಾರ್ಟೆಂಟ್ ಅಂತ ಹೇಳುವ ಪ್ರಿನ್ಸಿಪಲ್.
Be seated. Welcome. Objections are filed, saying jurisdictional issue. No, that's a revision. That's no second appeal as such. He is a soldier also.
The same judgment is held in the Madras High Court only on the jurisdiction, not on the main, because I'm a quasi-judicial person.
Okay. Give a copy to your friend also.
Subject matters which include the local bodies matters. The contention has been taken by the MUDA in the appeal also. The district forum doesn't have any jurisdiction on the allotment of site management.
Paragraph. There are two. No appeal lie. Correct. Correct. Therefore,
Even there is a state commission have a power to review the order, my lordship. They can go before the state commission to get it, the review the order also.
no. The case which you have cited is a matter where appeal lies to National Commission. Therefore, court should not have. Now it has no second appeal. Only first appeal ashta ide. Go to the next point. ಆ ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ ನೋಡಿ. Correct.
Yeah, I'll give only the three paras, my lordship. It is not always necessary to set aside an order if found to have been passed by an authority, court having no jurisdiction.
Correct.
This, they have not held this with this judgment, 1988 AC. This has been overruled by this, the present judgment.
What it says?
In 1988, it says the High Court has a jurisdiction, my lordship. It was continuing before the High Court that no appeal lay from the decision of the prescribed authority to the district judge. The High Court accepted this contention. On that ground, the High Court declined to interfere with the order of the learned single district judge. It is true that there has been some technical breach because if there is no appeal maintainable before the learned district judge, in the appeal before the learned district judge, the same could not be set aside. But the High Court was exercising its jurisdiction under Article 226 of the Constitution. The High Court had come to the conclusion that the order of prescribed authority was invalid and improper. High Court itself could have set aside. Therefore, in the facts and circumstances of the case, justice has been done though, as mentioned hearing before, technically the appellant had a point that the order of the district judge was illegal and improper. If we reiterate the order of the High Court as it's setting aside the order of the prescribed authority, its exercise of the jurisdiction under Article 226 of the Constitution, then no exception can be taken. As mentioned herein before, justice has been done and as the improper order of the prescribed authority has been set aside, no objection can be taken. In view of the above, it is not always necessary to set aside an order if found to have been passed by an authority, court having no jurisdiction.
Kindly come to page last but one paragraph, para 6 ಕೆಳಗಡೆ.
Like declining to interfere in the present special leave petition prepared against the order passed by the High Court in exercise of its extraordinary jurisdiction under Article 226 of the Constitution of India, we hereby make it clear that the order of commission or incapable of being questioned under the writ jurisdiction.
As a statutory appeal in terms of section 27 capital A lies to this court. An appeal lied to the apex court earlier. Therefore, court said, you cannot do that. Now, subsequently, this view is diluted. The apex court said, after the orders of the appeal in commission, they should go to the state courts only. There is such a judgment.
Even the Madras High Court in 2022, they have taken this judgment.
They have followed
This
this.
is not overruled, this judgment, this is still left, my lord. This is not overruled.
This judgment holds the field even today. No, that was a case where appeal lies to the Supreme Court. Give a Consumer Protection Act. There is no second appeal to the Central Commission. Review. But review, this court has taken the view, review is no alternate remedy because it is very, very restricted. But, just let us see.
Appeal to national.
27 capital A.
That is old act. The new act has been amended in 2000.
This is old act.
Yes, act. Now it is amended to 51 clause 1.
It's amended, saying what it says.
Appeal to National Commission, any
Ah.
person aggrieved by an order made by the State Commission in exercise of
State Commission.
any person aggrieved
Any
by
person aggrieved by an order made by the State Commission in the exercise of its powers conferred by subclause so and so of section 47. 47, but let us see 47. Subject to the shall have jurisdiction to entertain complaint. That is original order.
that is all.
Original order is the appeal lies to commission. But order in appeal by the commission, suppose.
But 51 clause 5, my lordship.
51 5.
They light the National Commission under this section from an order passed is ex parte by the State Commission.
No, you were referring to appeal to National Commission, na 51. Adರಲ್ಲಿ ಯಾವ್ದು ಗೊತ್ತಾ? You will lay a complaint before the State Commission. State Commission rejects it. Then National Commission. If you lay a complaint before the District Commission and matter is carried to the State Commission, that order is not appealable. Only one appeal.
They can file review petition, my lordship.
But the review we have held is not an alternate remedy because see that error apparent on the face of the record either on its own motion or an application made by the authorities, etc. State Commission, before the same commission, review is never considered as an alternate remedy.
Explanation provided further no appeal by a person who is required to pay any amount in terms of an order of the State Commission shall be entertained by the National Commission unless the appellant has deposited.
No, that does not apply to him. Read 27. 27 capital A. This was under be checked. No, that was a case where National Commission has passed the order. National Commission has original jurisdiction also. If monetary limit is above some crores, commission. Pecuniary. That against that order appeal is to Supreme Court. Against orders of the National Commission.
But dispute judgment, even National Commission order, they have challenged before the High Court.
That is wrong. Apex Court said that's a nullity because there is an appeal to the Supreme Court. Only Supreme Court has got power is the version of this judgment. Just examine again. Okay.
This is the recent judgment, though it is an old matter. Anyway, my lordship has told in the earlier other case, there are many.
Yes, we have held that way already. This, of course, you have to treat this also. Allah, he has given money. He is a soldier. He has given money. And he has given money subsequently, whatever was remaining. You have retained that money. You neither do not return that money, nor you give the site also. And what is the, how you are going to justify that?
Because there is a condition under Millard to forfeiture of the, in case if he failed to pay the.
That applies
subsequent
only when
installment.
notice is served on him.
Yes.
Notice was not served because he was transferred to some other place in Agartala. Therefore, notice ought to have been sent to him. So without notice, no forfeiture. Question.
Question is, so whatever the address given to the Millard, the authority, while filing application or at the subsequent dates, if he bring it to the notice of the authority saying that my present address is this for further communication and all. So we will follow that.
Yes, that
in the
will be-
absence of such communication.
That's right. That-
So
that
we are-
applies
we
only
are
to
unable
ordinary
to
people.
take action.
What happens?
This-
It applies to ordinary people. This fellow went to attend a Naxal problem. He was transferred to that place. Therefore, your notice did not reach him. At least after it came back, you should have ascertained that saying that where this man is, we want to send a reply to him. That way you should have done effort. He's a soldier. He's a combatant. He's a combatant soldier. He's an officer. Therefore, you can't say that, no, he was not available when we sent to notice. He will not be there. He's bound to be in mobility for protecting the frontiers of the country. Anyway, please be seated.
Annexure B 45 page.
Sit down,
number.
sit down, sit down.
Service
By
rec-
more arguing, you may dilute your argument. An ex-defense personnel is knocking at the doors of Writ Court for assailing the order dated 11/1/2024 made by the Karnataka State Consumer Dispute Redressal Commission, Bangalore, whereby appeal number 713 of 2017 filed by the first respondent Mysore Urban Development Authority, bracketnally Muda. You are like Bermuda. You are not Muda. You do trouble people. Having been favored, the District Consumer Disputes Redressal Forums Order dated 22/7/2016 has been set at naught. First, the district forum having allowed petitioner's complaint number 513 of 2015 by the subject order had granted relief to the petitioner by directing execution and registration of a regular sale deed in respect of subject site in favor of the petitioner. First stop. Next paragraph. Learned counsel appearing for the petitioner vehemently argues that the state forum adopted juridically a defective approach to the appeal in question, eventually resulting into its unjustified indulgence in the order of the district forum. In support of this contention, he draws attention of the court to the Mooda's allotment letter dated 25 February 2001, a copy whereof avails at Annexure C, whereby the subject site admeasuring 40 into 60 square feet was allotted to her client, and that the allottee had made a payment of rupees 1,60,000, a part of that, that is rupees 21,930 belatedly. First, the Mooda having accepted the belated payment did not yield the site to the petitioner on the ground that there is no provision in the extant allotment rules for condoning delay, even when interest for the delayed payment was remitted. Savika. She also highlights, full stop. She also highlights the human service rendered by the petitioner in guarding the frontiers of the country for decades, and with no black spot in the service records. First. Lastly, she adds that the courts and tribunals should be sympathetic to the cause of defense and ex-defense personnel so that they would evince more interest in protecting the borders of the country. First, all these aspects having not animated the order, impugned order of the State Commission, comma, she says, comma, amount to error apparent on the face of the record, warranting interference of this court. First, next paragraph. Learned after service of notice, Muda has entered appearance through its senior panel counsel, and the registrar of the State Commission, who happens to be the second respondent, also has entered appearance through the learned AGA. First off, both the panel counsel and the AGA vehemently opposed the petition, making submission in justification of the impugned order and the reasons on which it has been constructed. First off, learned AGA draws our attention to the apex court decision in Sicily Kallarakal versus Vehicle Factory, 2012, 8 SCC 524, to contend that the the petitioner has got alternate remedy of review under section 51 of the Consumer Protection Act 2019, and therefore he should be relegated to the alternate remedy, comma, there being no extraordinary circumstances to deviate therefrom. First, next, having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter for the following reasons. 1, 4.1, 3.1. The allotment of the site in question, comma, initially substantial payment towards sale price of rupees 1.60 lakh and subsequent payment of rupees 21,930.
21,000 is not paid by the, because they have refused it. Yeah, there is no provision ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Okay.
We have an access. Yeah.
Okay. Alone. Yeah, substantial payment in embroidery. And subsequent tender of payment, tender of money in a sum of rupees 21,930 are not in dispute. They are not in dispute. You have admitted it in your pleadings only.
Payment ಆಗಿಲ್ಲ. We have refused it.
Tender.
Please.
Tender is accepted. First off, true it is that the said tender of money was not accepted by the Muda
saying that there was no provision of law for acceptance of belated payment. Full stop. It is admitted at the bar that the notice dated 5/7/2014 sent to the petitioner calling upon him to make the payment due was not served on him in as much as a defense personnel, he was shifted to some other sensitive part of the country. Full stop. The question of delay would have figured in favor of the Muda had the notice been served on the defense personnel, and despite service, he refused to make payment, made payment demanded in the subject notice. First, this aspect of the matter having not been properly treated by the State Commission, there is error apparent on the face of impugned order. Next paragraph. The vehement contention of learned panel counsel appearing for the Muda that the allotment is subject to condition of making payment of the price of the allotment, and that having not been paid, the petitioner has got his right to have the conveyance forfeited is difficult to countenance. First, as already mentioned above, substantial payment was already made towards the sale price, allotment price. What was remaining was a small amount in a sum of rupees 21,930 only. The Muda could not act mechanically by invoking the rule of law. First, it is not the case of Muda that in no other instance the belated payments are accepted or are not accepted and allotments have been cancelled invariably. First off, ours is a constitutionally ordained state. Muda has been established under the provisions of Karnataka Urban Development Authorities Act 1987, and therefore answers the description of state under Article 12 of the Constitution of India. First, therefore, it cannot act like a colonial power. First off, its actions have to be animated with reason and justice. First off, when a notice sent by it returned unserved, what efforts were made
for substituted mode of service are not forthcoming from the pleadings. First, for the fault of the Muda, a defense personnel cannot be punished. First, even this aspect of the matter has not animated the impugned order of the State Commission, and that would add to accumulation of errors apparent on the record, on the face of the record. Next paragraph. The vehement submission of learned GA that in Sicily, Kallarkal, Supra, the apex court faltered interference of the High Court in a matter of the kind is difficult to countenance. Full stop. It was a case wherein the complaint was before the National Commission itself, and appeal availed against its order to the apex court. First off, it has long been settled position of law that against the appellate order of the State Commission, there is no second appeal. First off, review and revision ordinarily are not treated as equally efficacious and alternate remedy. First off. Next paragraph. In the above circumstances, this petition succeeds. Semicolon. A writ of certiorari issues, quashing the impugned order of the State Commission. Semicolon. As a consequence, the order of the District Disputes Redressal Forum Mysore is revived, restored and revived. First off, a direction issue, a writ of mandamus issues to the first respondent Muda to accomplish the allotment of subject site to the petitioner by executing and registering a regular sale deed in his favor if he makes a payment of rupees 21,930 plus interest at the rate of 9% per annum on the said amount, reckoned from the date the same was payable. First off, this payment should be made within 4 weeks. 4 weeks. First off. First off, time for compliance is 6 weeks after the payment is made. Okay. Costs made easy.
Instead of 6 weeks, it may be 8 weeks.
4 weeks our time ಕೊಡ್ಲಿಕ್ಕೆ 6 weeks. Totally ಎಷ್ಟು ಆಗ್ತದೆ? 10 weeks ಆಗ್ತದೆ.
ಇನ್ನೊಂದು in view of the revival of the order passed by the district forum, right? So the order portion you will actually make kindly see serial number 3 and 4. That may be my lord waive off for this reason, my lord, because we have filed the appeal and so where my lord 500 rupees per day has to be ordered to pay until the execution of sale deed. That was the direction issued by the consumer forum.
ಕರೆಕ್ಟ್ ಇದೆ ಅದು. ಈಗ ಈ ಡೇಟ್ ಇಂದ ಬರ್ತದೆ. ಸಪೋಸ್ ನೀವು ಕೊಡಲ್ಲ ಮತ್ತೆ ಸೋಲ್ಜರ್ ಹ್ಯಾಸ್ ಗಾಟ್ ಹಿಸ್ ಓನ್
From this date in
ಲೈಫ್ ನೌ.
Because we have challenged that order. So in view of the survival of revival of the order.
ಆಲ್ರೈಟ್, ಈಗ ಇಲ್ಲಿಂದ 500 ರೂಪಾಯಿ ಕೊಟ್ಕೊತ ಹೋಗಿ.
ಅಲ್ಲ ಇಲ್ಲಿಂದ from the date of default after 6 weeks ಅಂತ ಅಲ್ಲಿಂದ ಮಾಡಿದ್ರೆ if we failed then it.
ಫಸ್ಟ್ ಇದೆಲ್ಲ ಮಾಡಿದ್ದೇ ತಪ್ಪು. 1 ಲಕ್ಷ ರೂಪಾಯಿ 2 ಲಕ್ಷ ರೂಪಾಯಿ ದಂಡ ಹಾಕ್ಬೇಕು ನಿಮ್ಗೆ, ಆಯ್ತಾ? ಅವ್ರು ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ದವ್ರು ದಿವಸ 500 ರೂಪಾಯಿ ಕೊಡೋಕು ಅಂತ ಹಾಕ್ಯಾರೆ. ಎಷ್ಟಾಗ್ತದೆ ಅದು? 1000 ಆಗ್ತದೆ.
Until the compliance ಅಂತ ಇದೆ
2016 ನಿಂದ 8 ವರ್ಷ. 12 96 96 48 4,80,000 ರೂಪಾಯಿ ಆಗ್ತದೆ. ಕೊಡಿ, ಏನ್ ತಪ್ಪಿಲ್ಲ. ಬೇರೆ ಯಾರ್ಯಾರಿಗೂ ಕೊಡೋ ಬದ್ಲಿ ಯು ವಿಲ್ ಬಿ ಪೇಯಿಂಗ್ ಇಟ್ ಟು ದಿ ಡಿಫೆನ್ಸ್ ಮ್ಯಾನ್. ಅವರೆಲ್ಲ ತಮ್ಮ ಪ್ರಾಣತ್ಯಾಗ ಮಾಡ್ತಾರೆ.
because we filed appeal. That's why my lord, I seek intelligence of this honorable court to waive off that.
Correct. Why you filed appeal? Now appeal is failing. Now your appeal will go. Why did you file appeal? ನಿಮ್ ಬೇಕಾದವರಿಗೆಲ್ಲ ಸೈಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಮೂಡಾದ ಹಗರಣಗಳೆಲ್ಲ ಪೇಪರ್ ನಲ್ಲಿ, ಕೋರ್ಟ್ ಪೇಪರ್ಸ್ ನಲ್ಲಿ, ಕೋರ್ಟ್ ಕೇಸ್ ನಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆ ಇದೆ. ಸೋಲ್ಜರಿಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬಂದಾಗನೇ ಇವೆಲ್ಲ ಬರ್ತಾವ ನಿಮಗೆ. ಯಾರು ಬೇಕವ್ರಿಗೆ ನೀವು ಕೊಟ್ಟಿರಿ. And cases are here. Cases are in the neighboring court. Is it not? Let us forget the newspapers. But case papers are there. Correct. 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ.
That may be my lord, waive off my lord in view of the matter.
What is the reason? You give us reason. We'll consider. ಮೂಡ ಬಹಳ ಬಡವರು, ಬಹಳ ಒಳ್ಳೆಯವರು ಮೂಡಾದವರು ಎಲ್ಲ ಬರ್ಮುಡಾ ಟ್ಯಾಂಗಲ್ ಇದ್ದಂಗೆ ಇದ್ದೀರಿ ನೀವೆಲ್ಲ. ನಿಮ್ಮಲ್ಲಿ ಯಾರು ಬರ್ತಾರೋ ಅವ್ರು ಮುನಿಗೆ ಹೋಗ್ತಾರೆ. ಎಷ್ಟು ಜನರ ಲ್ಯಾಂಡ್ ಎಕ್ವೈರ್ ಮಾಡಿಕೊಂಡ್ರಿ, ಎಷ್ಟು ಜನ ಅನ್ವರ್ದಿ ಪೀಪಲ್ಗೆ ಸೈಟ್ಸ್ ಅನ್ನು ಅಲಾಟ್ ಮಾಡಿರಿ ನೀವು. ಇಲ್ಲಿ ಇರುವಂತ ಸೋಲ್ಜರಿ ಕೊಡಲ್ವಾ? ಇಡೀ ಲೈಫ್ ಬಾರ್ಡರ್ನೇ ಕಳ್ದಾನೆ. ಏನ್ ಅನ್ಕೋತಾರ ಅದರ್ ಸೋಲ್ಜರ್ಸ್? ಬೇರೆ ದೇಶದಲ್ಲಿ ಸೋಲ್ಜರ್ಸ್ ಅನ್ನು ಟ್ರೀಟ್ ಮಾಡೋ ರೀತಿ ನೋಡಿ ಎಷ್ಟು ಗೌರವ ಕೊಡ್ತಾರೆ. ಸೋಲ್ಜರ್ಸ್ ಎಲ್ಲ ಏರೋಡ್ರೋಮಿಗೆ ಬಂದ್ರೆ, ರೈಲ್ವೆ ಸ್ಟೇಷನ್ಗೆ ಬಂದ್ರೆ, ಬಸ್ ಸ್ಟ್ಯಾಂಡಿಗೆ ಬಂದ್ರೆ ಉಳಿದೋರು ಎದ್ದು ನಿಂತ್ಕೊಂಡು ಕ್ಲಾಪ್ಸ್ ಮಾಡ್ತಾರೆ, ಸೀಟ್ ಕೊಡ್ತಾರೆ ಅವ್ರಿಗೆ, ಸ್ವೀಟ್ಸ್ ಏನಾರ ಇದ್ದಿದ್ರೆ ಅವನ್ನೆಲ್ಲ ಕೊಡ್ತಾರೆ ಹೋಗಿ. ನಮ್ಮಲ್ಲಿ ಏನು ವಾಟ್ ಎ ಪ್ಯಾಥೆಟಿಕ್ ಕಂಡೀಷನ್. ಸೋಲ್ಜರ್ಸಿಗೆ ಆ ರೀತಿ ಟ್ರೀಟ್ ಮಾಡಿದ್ರೆ ಯಾವ ದೇಶದ ಬಾರ್ಡರ್ ಸೇಫ್ಲಿ ಉಳಿತದೆ? ನಮ್ಮ ಸಲುವಾಗಿ ಪ್ರಾಣತ್ಯಾಗ ಮಾಡ್ತಾರ ಅವ್ರು. ಹಂಗೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನೀವು ಈಗ ಇಲ್ಲ 4,80,000 ಆಗ್ತದೆ, ಇಲ್ಲ ಒಂದು ಫಿಗರ್ ಹೇಳಿ ಅಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕ್ತೇನೆ ನಾನು. ವೇರ್ ಹಿ ಶುಡ್ ಗೋ, ವೇರ್ ದ ಸೋಲ್ಜರ್ ಶುಡ್ ಗೋ? ಸಿಂಪಲ್ ಕ್ವಶನ್ ನಮ್ಗೆ. ಅವರೆಲ್ಲ ಅಲ್ಲಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ನಾವೆಲ್ಲ ಸೇಫ್ ಆಗಿದ್ದೇವಿ. ನೀವು ಅವರನ್ನೇ ಮರ್ತು ಬಿಟ್ರೆ ಯಾರನ್ನ ನೀವು ಗ್ರಾಟಿಟ್ಯೂಡ್ ಇಟ್ಕೋತೀರಿ? ಯಾರ್ಯಾರಿಗೋ ಕೊಟ್ಟಿರಿ ನೀವು ಸೈಟ್ಗಳನ್ನ. ಐ ವಿಲ್ ನಾಟ್ ಡೆಲಿಬ್ರೇಟ್ ಮೋರ್ ಆನ್ ದಟ್. ತುಂಬಾ ಜನ ನೋಡ್ತಿರ್ತಾರೆ ನಮ್ಮ ವಿಡಿಯೋಗಳನ್ನ, ಹಂಗಾಗಿ ಜಾಸ್ತಿ ಹೇಳಲ್ಲ ನಾನು. ಸೋಲ್ಜರಿಗೆ ಕೊಡಲ್ವಾ? ಏನಿಲ್ಲ, ಕೊಡಿ. ಆಯ್ತು, ಆ ಪ್ರಕಾರ ಅಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು. ಅಥವಾ ಎಂಟೈರ್ ಪೇಮೆಂಟ್ ಮಾಡೋದು. 16 ಅಂತ ಅನ್ಕೊಂಡ್ರೆ 18 or 14 8 ವರ್ಷ ಆಗ್ತದೆ. 12 × 8 12 ಎಂಟ್ಲೆ 96 96 ಡಿವೈಡೆಡ್ ಬೈ 2 ವಿಲ್ ಬಿ 48 4,80,000 ಆಗ್ತದೆ. ಅಷ್ಟು ಅಮೌಂಟ್ ಅನ್ನು ನೀವು ಕೊಡಬೇಕು. ಅದನ್ನ ನೀವು ಯಾರಾದ್ರ ಕೈಯಿಂದ ರಿಕವರ್ ಮಾಡಿ. ಈಗ ನೀವೇ ಅಮೌಂಟ್ ಕೊಡದಿದ್ರೆ ಈಗಿಲ್ಲ, ಒಂದು ಕೆಲಸ ಮಾಡ್ತೀವಿ, ಅವ್ರು ₹1 ಕೊಡಲ್ಲ. ಈಗ ನೇರವಾಗಿ ಮರ್ಯಾದೆಯಿಂದ ನಿಮ್ಮ ಕಮಿಷನರ್ ಬಂದ್ಕೊಂಡು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು ಸೇಲ್ ಡೀಡ್ ಅನ್ನು. 4 weeks ನಲ್ಲಿ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಅದು ಮಾಡಂಗಿದ್ರೆ ಹೇಳಿ, ನಾವು ವೇವ್ ಮಾಡ್ತೇವೆ. ಆಗಿದ್ದಾಗಿ ಇವತ್ತು ವಿಲ್ ಟೆಲ್ ಅವರ್ ಸೋಲ್ಜರ್, ಏನೋ ಹಿಂಗಾಗಿದೆ, ಕ್ಷಮ ಮಾಡಿಬಿಡಿ ಅವ್ರನ್ನ ಅಂತ. Tell us.
In case default in executing the sale deed as directed by this honorable in this writ petition, if we fail to then this condition may be.
ಎಷ್ಟು ವರ್ಷ? ಯಾವಾಗ ಅಲಾಟ್ಮೆಂಟ್? 2001. ಜೀವಂತ ಇದ್ದಾನ ಸೋಲ್ಜರ್. ಅದಕ್ಕೆ ಯು ಶುಡ್ ಥ್ಯಾಂಕ್ ಗಾಡ್ ಫಾರ್ ದಟ್.
So,
Yes.
sorry, sir.
Sir, I'm the one who's affected. I'm perforce, I have to come before you, bow down my head and ask for the justice. You don't know my background. I'm a distinguished general of Indian Armed Forces. I joined Armed Forces October 1977 after graduation from Mysore Medical College. It is my pure love for the country which drove me to the armed forces. I was posted as a soldier, as a young.
ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿ.
ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೀನಿ ಸರ್. ಏನಂತಂದ್ರೆ 1977ರಲ್ಲಿ ನಾನು ಹೈ ಆಲ್ಟಿಟ್ಯೂಡ್ ನನ್ನ ಪೋಸ್ಟಿಂಗ್ ಆಯ್ತು. ಹೈ ಆಲ್ಟಿಟ್ಯೂಡ್ ಅಂತಂದ್ರೆ ಕಾರ್ಗಿಲ್. ಅದರ ಹೈಟು 10,000ದಿಂದ 20,000 ಅಡಿ ಎತ್ತರ. -30 ಡಿಗ್ರಿ ಸೆಂಟಿಗ್ರೇಡ್. ಆಕ್ಸಿಜನ್ ತುಂಬಾ ಅಭಾವ ಇದೆ. ಅಲ್ಲಿ ಯಾರು ಹೋಗ್ತಾರೋ ಅವ್ರ ಲಂಗ್ಸ್ ನೀರು ತುಂಬಿಕೊಡ್ತದೆ, ತಲೆ ನೀರು ತುಂಬಿಕೊಡ್ತದೆ. ದೇ ಬಿಕಮ್ ಅನ್ಕಾನ್ಶಿಯಸ್, ದೇ ಡೈ. I survived that environment for 28 months. I rescued 8 people. I almost sacrificed my life. I got the President Award, Guarantee Award. Then I was posted to 20 different places. Wherever I went, I did my job in the best interest of the country. ಈ ಸೈಟ್ ನನಗೆ ಅಲಾಟ್ ಆಗಲಿಕ್ಕೆ ಒಂದು ಹೇಳ್ತೇನೆ. ಆ ಸಮಯದಲ್ಲಿ 1994ರಲ್ಲಿ ನಾನು ಡೆಹ್ರಾಡೂನ್ನಲ್ಲಿ ಪೋಸ್ಟೆಡ್ ಆಗಿದ್ದೆ. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಡಿವೈನ್ ಲೈಫ್ ಸೊಸೈಟಿ ಜೊತೆ ನನಗೆ ಅಸೋಸಿಯೇಷನ್ ಇತ್ತು. ಅಲ್ಲೇ ಸೆಕ್ರೆಟರಿ, ಅವರಿಗೆ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು, ಹಾಗಾಗಿ ಐ ಯೂಸ್ ಟು ಟೇಕ್ ಕೇರ್ ಆಫ್. ಮೈಸೂರಿಂದ ಒಬ್ಬ ಜಡ್ಜ್ ಬಂದಿದ್ರು, ಅವ್ರ ಶಿಷ್ಯರು. ಅವ್ರು ನನಗೆ ಹೇಳಿದ್ರು, ಮೂಡಾದಲ್ಲಿ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಆಗಿದೆ, ವೈ ಕಾಂಟ್ ಯು ಅಪ್ಲೈ? ಐ ಫೆಲ್ಟ್ ವೆರಿ ಹ್ಯಾಪಿ. ಐ ಡಿಡ್ ಮೈ MBBS ಫ್ರಮ್ ದೇ. ಐ ವಾಂಟೆಡ್ ಟು ಹ್ಯಾವ್ ಸಮ್ ಪ್ಲೇಸ್ ಅಂತ ಹೇಳಿ ಅಪ್ಲೈ ಮಾಡಿದ. ಆ ಸಮಯದಲ್ಲಿ ಹಣದ ಅಭಾವ ಇತ್ತು. ಆದರೂ ಕೂಡ ನಾನು ಇನಿಷಿಯಲ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೆ 1994ರಲ್ಲಿ. 6 ವರ್ಷ ಕಾಯ್ತಾಬೇಕು. ಆಮೇಲೆ ಸಡನ್ ಆಗಿ ಒಂದು ದಿವಸ ಇವರು ಲೆಟರ್ ಕಳಿಸ್ತಾರೆ. ಅದು ನನಗೆ ಸಿಕ್ಕಿಲ್ಲ. ರಜದಲ್ಲಿ ಬಂದೆ. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಮಿಲಿಟರಿ ಹಾಸ್ಪಿಟಲ್ ನಾಮಕಂತ ರಾಂಚಿಯಲ್ಲಿದ್ದೆ, ರಾಂಚಿ ಜಾರ್ಖಂಡ. ರಜದಲ್ಲಿ ಬಂದಾಗ ಇವರು ನನಗೆ ಯಾವ ಕೋಪರೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ. 3 ಕಮಿಷನ್ನ ಭೇಟಿಯಾಗಲಿ ಸಾಧ್ಯವೇ ಇಲ್ಲ. ಅಲ್ಲಿ ಹೋಗಿ ಕ್ಲರ್ಕ್ ಹತ್ರ ಕೇಳಿದಾಗ ಕ್ಲರ್ಕ್ ಹೇಳ್ತಾನೆ, ಇದು ನಿಮ್ಮ ಅಮೌಂಟು, ಇದಕ್ಕಿಷ್ಟು ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಅಂತ. ನನಗೆ ಡ್ರಾಫ್ಟ್ ಮಾಡಬೇಕಾದ್ರೆ ಲೋಕಲ್ ಯಾವ್ದು ಅಕೌಂಟ್ ಇರಲಿಲ್ಲ, ಅವಾಗ ಆನ್ಲೈನ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇರಲಿಲ್ಲ. ಆದರೂ ಕಷ್ಟಪಟ್ಟು ಐ ಅರೇಂಜ್ ದ ಮನಿ ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ್ದ. ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಕೊಟ್ಟಾಗ ಇವನು ಹೇಳ್ತಾನೆ, ಯುವರ್ ಲೇಟ್ ಪೇಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾನೆ. ರೆಸಿಪ್ಟ್ ಕೊಡ್ತಾನೆ, ಫೈನಲ್ ಪೇಮೆಂಟ್ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕು ಅಂತಂದ್ರೆ ಅದು ಹೇಳಲಿಲ್ಲ. ನೋ ಕಮ್ಯುನಿಕೇಶನ್ ವಾಟ್ಸ್ಆಪ್. ಅಲ್ಲಿಂದ ಕೇಳಿ ಸರ್. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ನಾನು ಹೋಗಿ ಕೇಳಿ, ಏನಾಯ್ತಪ್ಪ ನನ್ನ ಸೈಟಿಗೆ ಅಂತ ಹೇಳಿದಾಗ ಇವ್ರು ಹೇಳ್ತಾರೆ, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ, ನಿಮಗೆ ಯು ಆರ್ ನಾಟ್ ಎಂಟಲ್ಡ್ ಫಾರ್ ದ ಸೈಟ್, ಯು ಆರ್ ನಾಟ್ ಪೇಡ್ ದ ಮನಿ ಅಂಡ್ ದೇರ್ ಇಸ್ ನೋ ಪ್ರಾವಿಷನ್ ಟು ಟೇಕ್ ದಿಸ್ ಮನಿ. 2014 ಆ ಲೆಟರ್ ಕೋಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ವಿಚ್ ಇಸ್ ಕೋಟೆಡ್ ಬೈ ದಿ ದಿಸ್ ಒನ್, ದ ಸ್ಟೇಟ್ ಕಮಿಷನ್. ದಟ್ ಇಸ್ ರಾಂಗ್ಲಿ ಕೋಟೆಡ್. It is very clearly written that there is no provision. Now you are talking, I am begging to meet the Board of Commission, impossible. Then finally, this one, sir. I don't want title, I want honor.
Anyway, now you have been granted good.
Thank you so much. Adhikosara, thank you.
Thank you. We have great respect for soldiers. Great respect for, great admiration for soldiers like you.
Sir, I saw the country, sir. I was a physician to the President of India. Okay, I looked after the Field Marshal Manik, sir.
Yes.
Thank you so much.
ನೋಡಿ, ಎಂಟೈರ್ ಅಮೌಂಟ್ ಕೊಡಬೇಕು. 3 months ಇಟ್ಟಿವಿ, ಫುಲ್ ಅಮೌಂಟ್ ಕೊಡಬೇಕು. ಈಗ ಅವ್ರ ಅಮೌಂಟ್ ಕೊಡೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ನೀವು ಕೊಡೋದಿದೆ. ಈ ಅಮೌಂಟ್ ಕೊಡೋದಿದೆಯಲ್ಲ, ಅವರು ಅದನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡಿಕೊಂಡು ಅಷ್ಟು ಅಮೌಂಟ್ ಅವ್ರಿಗೆ ಕೊಡಿ, ಪ್ಲಸ್ ಸೈಟ್ ಅನ್ನು ಕೊಡಿ. ಸೈಟ್ ಅನ್ನು ಕೊಡಿ. ಆ ಅಮೌಂಟ್ ಅನ್ನ ಯಾರು ಎರಿಂಗ್ ಆಫೀಸರ್ಸ್ ಇದ್ದಾರಲ್ಲ, ನೋಡಮ್ಮ, ದ ಅಮೌಂಟ್ ಪೇಬಲ್ by virtue of the order of the district commission on being paid after deduction of the amount which the petitioner has to pay to make good the deficiency, comma, can be recovered from the erring officials of the MODA in accordance with law.
My request may be
In request.
to waive off that.
No, how it is that request? ಏನ್ ನಾಳೆ ಇಷ್ಟು ಜನ ಸೋಲ್ಜರ್ಸ್ ಎಲ್ಲ ಏನಂತಾರ ನಮ್ಗೆ, ನಾಳೆ ಶಾಪ ಹಾಕ್ತಾರೆ ನಮ್ಗೆ ಅವ್ರು. ದೇ ವಿಲ್ ಕರ್ಸ್ ಅಸ್. ಬೇರೆ ದೇಶದಲ್ಲಿ ಸೋಲ್ಜರ್ಸ್ ಅನ್ನು ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡ್ತಾರೆ, ನಮ್ ದೇಶದಲ್ಲಿ ಯಾವ ರೀತಿ ಟ್ರೀಟ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಶೇಮ್ ಅನಿಸ್ತದೆ. More I will not say because many people will be watching our video. Only this much we will say. Absolutely gratitude ಇಲ್ಲದ ರೀತಿಯಲ್ಲಿ ಅಧಿಕಾರಿಗಳು ನಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. ಎಸ್ಪೆಷಲಿ ನಮ್ಮ ಸೈನಿಕರ ವಿಷಯ ಬಂದಾಗ ಏನೂ ಗೌರವ ತೋರಿಸ್ತಾ ಇಲ್ಲ ನೀವು. ಪೊಲೀಸರ ವಿಷಯ ಬಂದಾಗ ಅವ್ರಿಗೆ ಏನೂ ಗೌರವ ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಆ ರೀತಿ ಆದ್ರೆ ಅವರಿಗೆ ನಮ್ಮ ದೇಶ ನಾವು ಕಾಯ್ಬೇಕು, ನಮ್ಮ ಮಾತೃಭೂಮಿಯನ್ನ ಉಳಿಸ್ಕೊಳ್ಬೇಕು ಅನ್ನೋ ಭಾವನೆ ಬರೋದು ಹೆಂಗಪ್ಪ? ಏನಿಲ್ಲ, ಕರೆಕ್ಟ್ ಇದೆ ಆರ್ಡರ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಚಲ.
ಏನು ಅದನ್ನೇ ಕೇಳಿದ್ದು ಕೊನೆಯಲ್ಲಿ. ಅದಕ್ಕೆ ಕೊನೆಯಲ್ಲಿ ಹೇಳಿದ್ದು ನಾನು